Paper, Code of Civil Procedure, 1908 and Limitation Act, 1963. 1 Question 1. What do you understand by suit of civil nature? What is the jurisdiction of civil courts? What do you understand by suit of civil nature? What is the jurisdiction of civil courts? Suit of civil nature. A suit of civil nature is a legal proceeding initiated in a civil court to enforce a right or seek redress for a civil wrong, as opposed to criminal or quasi-criminal matters. Section 9 of the CPC is the pivotal provision that defines the scope of civil suits, stating, "The courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature excepting suits of which their cognizance is either expressly or impliedly barred." This provision establishes that civil courts have a broad jurisdiction to entertain suits involving civil rights, unless such jurisdiction is barred by specific legal provisions. Essential characteristics. A suit of civil nature typically involves disputes concerning private rights, rights pertaining to property, contracts, torts, family matters, or other personal obligations. Civil wrongs, breaches of civil rights, such as breach of contract, negligence, or disputes over inheritance. Legal remedies, claims for remedies like damages, injunctions, specific performance, or declarations. For instance, a dispute between two parties over the ownership of a piece of land or a breach of a commercial contract constitutes a suit of civil nature. However, matters like criminal offenses, e.g., theft, or assault, or purely religious disputes without civil consequences fall outside this scope. Exceptions to jurisdiction. Section 9 specifies that civil courts cannot entertain suits where their jurisdiction is expressly or impliedly barred. These bars arise from express bar, specific statutes that vest jurisdiction in specialized tribunals, such as the Industrial Disputes Act, 1947 for labor disputes, or the Family Courts Act, 1984 for matrimonial disputes. Implied bar, situations where the nature of the dispute or the relief sought inherently excludes civil court jurisdiction, such as purely religious or ceremonial disputes without civil implications. Example, a dispute over the appointment of a temple priest, which involves only religious rights, may not be a suit of civil nature unless it impacts property or other civil rights. 2 Leading case, Most Reverend PMA Metropolitan v. Moran Mar Marthoma. The Supreme Court in Most Reverend PMA Metropolitan v. Moran Mar Marthoma, Air 1995 SC 2001, elucidated the scope of a suit of civil nature. The case involved a dispute within the Malankara Syrian Christian community over the management of church properties and the validity of certain religious practices. The court held that disputes involving property rights or civil consequences, even if arising from religious contexts, fall within the ambit of a suit of civil nature under Section 9. The court emphasized that civil courts have jurisdiction unless expressly or impliedly barred by statute. In this case, the plaintiff sought a declaration regarding the control of church properties and the validity of a constitution governing the church. The Supreme Court ruled that since the dispute involved property rights and governance issues with civil implications, it was a suit of civil nature, and the civil court had jurisdiction to adjudicate. Illustration: consider a scenario where A sells a piece of land to B under a registered sale deed, but C claims ownership based on an earlier unregistered agreement. B files a suit for a declaration of title and an injunction to restrain C from interfering with possession. This is a suit of civil nature, as it involves property rights and seeks civil remedies. The civil court would have jurisdiction under Section 9, provided no other statute bars such jurisdiction. Jurisdiction of civil courts. Jurisdiction refers to the authority of a court to hear and decide a case. The CPC outlines various types of jurisdiction that civil courts exercise, ensuring that disputes are adjudicated by the appropriate forum based on the nature, value, and location of the dispute. Types of jurisdiction. Civil courts exercise jurisdiction in several dimensions, as outlined below. Subject matter jurisdiction. Subject matter jurisdiction refers to the court's authority to adjudicate specific types of disputes. Under Section 9, civil courts can hear all suits of a civil nature unless barred. For example, disputes over property, contracts, torts, or family matters fall within this jurisdiction. Case law, Ananti v. Chanu, Air 1930 All 193. In this case, the court held that a dispute over the partition of joint family property was a suit of civil nature, as it involved property rights, and the civil court had jurisdiction to adjudicate 3. Pecuniary jurisdiction. Pecuniary jurisdiction is determined by the monetary value of the suit, as specified under Section 15 of the CPC, which mandates that every suit be instituted in the court of the lowest grade competent to try it. The pecuniary limits of courts vary by state and court hierarchy, e.g., district courts, subordinate courts. Example, if a plaintiff seeks Rs 10 lakhs as damages for breach of contract, the suit must be filed in a court with pecuniary jurisdiction to handle claims of that value, such as a district court, rather than a lower grade court. Territorial jurisdiction. Territorial jurisdiction is governed by Sections 16 to 20 of the CPC. These provisions specify where a suit must be filed based on the location of immovable property, Section 16. The place where the cause of action arises, Section 20. The residence or place of business of the defendant, Section 20. Example, in a suit for recovery of money under a contract executed in Mumbai, where the defendant resides in Delhi, the plaintiff may file the suit in either Mumbai, where the cause of action arose, or Delhi, where the defendant resides, per Section 20. Personal jurisdiction. Personal jurisdiction refers to the court's authority over the parties involved. A court has jurisdiction over defendants who reside, carry on business, or work for gain within its territorial limits, Section 20. Additionally, parties may consent to a court's jurisdiction through agreement or by not objecting to it. Limitations on jurisdiction. Civil court jurisdiction is subject to limitations imposed by statutory bars. Other statutes may vest jurisdiction in specialized tribunals, such as the Debt Recovery Tribunal under the Recovery of Debts Due to Banks and Financial Institutions Act, 1993. Residential judicata, Section 11 of the CPC bars relitigation of issues already decided by a competent court between the same parties. Limitation Act, 1963, suits must be filed within the prescribed time limits under the Limitation Act, failing which the court may dismiss the suit as time-barred. For leading case, Dhulabhai v. State of Madhya Pradesh. In Dhulabhai v. State of Madhya Pradesh, Air 1969 SC 78, the Supreme Court laid down principles to determine when civil court jurisdiction is barred. The case involved a challenge to tax assessments, where the plaintiffs argued that the civil court had jurisdiction despite provisions in the Madhya Pradesh General Sales Tax Act. The court held that civil court jurisdiction is excluded only when the statute provides a complete remedy through a special tribunal. The statute expressly or impliedly bars civil court jurisdiction. The court emphasized that any doubt regarding the exclusion of civil court jurisdiction should be resolved in favor of retaining jurisdiction, underscoring the expansive scope of Section 9. Interplay with the Limitation Act, 1963. The Limitation Act, 1963 prescribes time limits for instituting suits, ensuring that claims are pursued diligently. Section 3 of the Act mandates that a suit filed after the prescribed period is liable to be dismissed, even if limitation is not raised as a defense. Relevant provisions. Section 3 bars suits filed beyond a limitation period. Schedule specifies limitation periods for various suits, e.g., 3 years for suits for recovery of money, Article 113, or possession of immovable property, Article 65. Section 5 allows condonation of delay in filing appeals or applications, but not suits, if sufficient cause is shown. Example, a plaintiff seeking to recover a debt due in 2020 must file the suit by 2023, 3 years under Article 19. If filed in 2025, the suit is time-barred unless an exception, e.g., acknowledgement of debt under Section 18, applies. Case law, State of Punjab v. Gurdev Singh. In State of Punjab v. Gurdev Singh, Air 1991 SC 2219, the Supreme Court held that the Limitation Act is a statute of repose, designed to protect defendants from stale claims. The court dismissed a suit filed beyond the prescribed period, emphasizing that courts must strictly enforce limitation periods unless statutory exceptions apply. Practical implications and analysis. The concept of a suit of civil nature and the jurisdiction of civil courts are foundational to civil litigation in India. Section 9 of the CPC ensures that civil courts serve as the default forum for resolving civil disputes, promoting access to justice. However, the jurisdiction is not absolute and is curtailed by statutory bars and the Limitation Act. The principles laid down in cases like Most Reverend PMA Metropolitan and LL.B underscore the judiciary's role in balancing the broad jurisdiction of civil courts with statutory limitations. The Limitation Act complements the CPC by ensuring timely litigation, preventing the abuse of judicial processes through delayed claims. However, provisions like Section 5, Condonation of Delay, and Section 18, Acknowledgement, provide flexibility to balance justice and technicality. Illustration: suppose A files a suit in 2025 to recover a plot of land sold to B in 2010, claiming fraud. The limitation period for such a suit is 3 years from the date the fraud was discovered, Article 59. If A discovered the fraud in 2022, the suit is within time. The civil court would have jurisdiction under Section 9, provided no other statute bars it, and the suit is filed in the appropriate court based on pecuniary and territorial jurisdiction. 6. Question 2. Define decree. What are the essential elements of a decree? Define decree. What are the essential elements of a decree? The Civil Procedure Code, 1908, CPC, serves as the backbone of civil litigation in India, providing a structured framework for the adjudication of civil disputes. Among its pivotal concepts is the term decree, which represents the formal expression of a court's adjudication in a civil suit. Understanding the definition and essential elements of a decree is fundamental for any law student, as it forms the cornerstone of civil judgments and their enforceability. Additionally, the Limitation Act, 1963, governs the time frame within which a decree can be enforced or appealed, making it an integral aspect of this discussion. This paper elucidates the definition of a decree, its essential elements, and their practical implications, supported by landmark judicial pronouncements and illustrative examples. Definition of decree under the CPC, 1908 Section 2 of the Civil Procedure Code, 1908, defines a decree as follows. Decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit and may be either preliminary or final. It shall be deemed to include the rejection of a plaint and the determination of any question under Section 144, but shall not include, a. any adjudication from which an appeal lies as an appeal from an order, or, b. any order of dismissal for default. This definition encapsulates the essence of a decree as a formal judicial pronouncement that resolves disputes between parties in a civil suit. The decree is the culmination of the court's adjudication process, determining the substantive rights of the parties involved. It is distinguished from an order, defined under Section 2(14) of the CPC, by its conclusive nature and appealability as a decree. The CPC distinguishes between preliminary and final decrees. A preliminary decree adjudicates some, but not all, issues in a suit, leaving certain matters for further determination. For instance, in a partition suit, a preliminary decree may determine the shares of the parties, while the final decree allocates specific properties. A final decree, conversely, fully disposes of the suit, leaving no further issues to be adjudicated. Essential elements of a decree. For a judicial pronouncement to qualify as a decree under Section 2 of the CPC, it must satisfy the following essential elements. 1. Formal expression of adjudication. The decree must be a formal pronouncement, typically in writing, reflecting the court's decision. It is not a mere oral statement but a documented judgment that adheres to the procedural requirements of the CPC. 7.2. Conclusive determination of rights. The decree must conclusively determine the rights of the parties with respect to the matters in controversy. This determination must be definitive, resolving the dispute either wholly, final decree, or partially, preliminary decree. 3. Adjudication in a suit. The decree must arise from a suit, which is a civil proceeding instituted by the presentation of a plaint, Section 26, CPC. The term suit excludes proceedings like applications under the Arbitration Act, 1940, or writ petitions. 4. Matters in controversy. The decree must address the issues or disputes raised in the suit, whether substantive, e.g., property rights, or procedural, e.g., jurisdiction. 5. Of certain orders. The definition explicitly excludes adjudications that are appealable as orders, under Section 104 and Order 43, Rule 1, and dismissals for default, which do not involve a substantive determination of rights. To illustrate, consider a suit for recovery of money. If the court adjudicates that the defendant owes the plaintiff 500,000 and issues a written judgment to that effect, it constitutes a decree because it formally and conclusively determines the plaintiff's right to recover the amount. However, if the suit is dismissed due to the plaintiff's failure to appear, it is an order of dismissal for default and not a decree. Landmark case laws on decrees. The judiciary has played a pivotal role in clarifying the scope and application of decrees under the CPC. Below are some landmark cases that elucidate the essential elements of a decree. Venkata Reddy v. Pethi Reddy, Air 1963 SC 992. In this seminal case, the Supreme Court clarified the distinction between a decree and an order. The court held that for a pronouncement to qualify as a decree, it must conclusively determine the rights of the parties with respect to the matters in controversy. The case involved a dispute over the partition of joint family property, where the trial court issued a preliminary decree determining the shares of the parties. The Supreme Court emphasized that a preliminary decree is as much a decree as a final one, as it satisfies the requirement of conclusive determination, albeit partially. This case underscores the element of conclusive determination. The preliminary decree in a partition suit conclusively determines the shares of the parties, even though further proceedings are required to allocate specific properties. The court also clarified that the formal expression of adjudication must be in writing, signed by the judge, and pronounced in open court, Order 20, Rule 6, CPC. Maiden Naik v. Hansubala Devi, Air 1983 SC 676. In this case, the Supreme Court addressed the issue of whether the rejection of a plaint constitutes a decree. The court held that the rejection of a plaint under Order 7, Rule 11 of the CPC is explicitly included in the definition of a decree under Section 2.2. In the case, the plaint was rejected due to a non-payment of requisite court fees. The court ruled that such rejection conclusively determines the plaintiff's right to proceed with the suit, thereby qualifying as a decree. This case highlights the element of inclusion of specific adjudications in the definition of a decree. The rejection of a plaint, though a procedural determination, has a substantive impact on the plaintiff's rights, making it a decree appealable under Section 96 of the CPC. Shankar Balwant Lokhand v. Chandrakant Shankar Lokhand, 1995, 3 SCC 413. This case dealt with the distinction between preliminary and final decrees in the context of a partition suit. The Supreme Court held that a preliminary decree determines the rights and liabilities of the parties, while the final decree effectuates those rights by allocating specific properties. The court clarified that both types of decrees satisfy the requirements of Section 2.2, as they involve formal adjudication and conclusive determination. This case reinforces the elements of formal expression and conclusive determination, emphasizing that a decree may be preliminary or final depending on the stage of adjudication. It also illustrates the procedural requirement that a decree must arise from a suit. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, prescribes time limits for initiating legal proceedings and enforcing decrees, making it an essential complement to the CPC. The enforceability and appealability of a decree are subject to the time periods specified in the Limitation Act. Execution of decrees under Article 136 of the Limitation Act, 1963, the period for executing a decree, other than a decree granting a mandatory injunction, is 12 years from the date the decree becomes enforceable. For example, if a decree for recovery of property is passed on January 1, 2010, the decree holder must apply for execution by January 1, 2022, failing which the decree becomes time-barred. In Anantharayu Shetty v. Apohej, the Kerala High Court held that the limitation period for executing a decree begins when the decree becomes enforceable, which may be delayed if the decree is subject to an appeal. This case illustrates the practical importance of the Limitation Act in the context of decrees, ensuring that decree holders act diligently to enforce their rights. Appeals from Decrees. Section 96 of the CPC provides for appeals from original decrees, subject to the time limits prescribed by the Limitation Act. Under Article 116, the period for filing an appeal to a high court is 90 days from the date of the decree, and to any other court, it is 30 days. For instance, in a suit for specific performance, if the trial court passes a decree on March 1, 2025, the aggrieved party must file an appeal by May 30, 2025, in the High Court. In this case, the Supreme Court emphasized that the limitation period for filing an appeal begins from the date of the decree, not the date of knowledge of the decree, unless fraud or concealment 9 is proven. This underscores the importance of adhering to statutory time limits to preserve the right to appeal. Practical implications and examples to further elucidate the concept of a decree, consider the following scenarios. 1. Suit for partition. In a suit for partition of joint family property, the court may pass a preliminary decree determining the shares of each co parsoner, e.g., 1/4 share to each of 4 brothers. This decree satisfies the elements of formal expression, written judgment, conclusive determination, of shares, and arises from a suit. A final decree is passed after a commissioner allocates specific portions of the property. 2. Suit for recovery of debt. In a suit for recovery of 1000,000, the court adjudicates that the defendant is liable to pay 800,000 with interest. The written judgment, specifying the amount and terms, constitutes a decree. If the defendant fails to pay, the decree holder can apply for execution within 12 years, as per the Limitation Act. 3. Rejection of plaint. If a plaintiff files a suit without paying the requisite court fee, and the court rejects the plaint under Order 7, Rule 11, this rejection is a decree because it conclusively determines the plaintiff's right to proceed with the suit. The plaintiff may appeal this decree within 90 days, Article 116, Limitation Act. 10. Question 3. What is the doctrine of res judicata? Explain with suitable illustrations its scope and limitations. What is the doctrine of res judicata? Explain with suitable illustrations its scope and limitations. Understanding the doctrine of residential judicata. Definition and legal basis. The doctrine of residential judicata is encapsulated in Indiana's Section 11 of the CPC, which states that no court shall try any suit or issue in which the matter directly and substantially in issue has been adjudicated by a competent court in a former suit between the same parties or those claiming under them, litigating under the same title, and has been decided on merits. The provision aims to prevent multiplicity of suits, conserve judicial resources, and protect parties from vexatious litigation. The essential ingredients of residential judicata are: a. The matter must have been directly and substantially in issue in the former suit. b. The former suit must have been decided by a court of competent jurisdiction. c. The parties in both suits must be the same or their representatives. d. The parties must have litigated under the same title. e. The matter must have been finally decided on merits. Objective and rationale. The doctrine serves multiple purposes: finality of judgments, it ensures that judicial decisions are conclusive, fostering public confidence in the judiciary. Judicial economy, it prevents courts from being burdened with repetitive cases. Protection against harassment, it shields litigants from being dragged into endless litigation over the same dispute. Scope of residential judicata application in civil suits. The scope of residential judicata extends to all civil suits where the conditions under Section 11 are satisfied. It applies not only to the entire suit but also to specific issues within a suit, known as issue estoppel. The doctrine bars relitigation of the same cause of action or issues that were or could have been raised in the former suit. For instance, consider a scenario where A sues B for recovery of a debt of INR 50,000 based on a promissory note. The court dismisses the suit, finding the note was not executed by B. If A11 files another suit claiming the same debt based on the same note, the second suit would be barred by residential judicata because the matter was already adjudicated. Constructive residential judicata. Explanation 4 to Section 11 introduces the concept of constructive res judicata, which prevents parties from raising issues in a subsequent suit that could and should have been raised in the former suit. This principle ensures that all related claims are consolidated in one proceeding. Illustration: A files a suit against B for possession of a property, claiming ownership based on a sale deed. The suit is dismissed as A fails to prove the deed's validity. Later, A files another suit claiming possession based on adverse possession. This second suit is barred by constructive residential judicata because A could have raised the adverse possession claim in the first suit. Residential judicata in execution proceedings. The doctrine also applies to execution proceedings under Section 47 of the CPC, which deals with questions arising between parties to a suit regarding the execution, discharge, or satisfaction of a decree. For example, if a question regarding the validity of a decree is decided in an execution proceeding, it cannot be relitigated in a fresh suit. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, prescribes time limits for filing suits, appeals, and applications. While residential judicata prevents relitigation of decided matters, the Limitation Act may bar a suit if filed beyond the prescribed period, even if residential judicata does not apply. For instance, under Article 59 of the Limitation Act, a suit to cancel or set aside an instrument must be filed within 3 years. If a party attempts to relitigate a matter by framing it as a new cause of action to circumvent residential judicata, the Limitation Act may still bar the suit if the time limit has expired. Illustration: A files a suit to declare a sale deed void, which is dismissed on merits. A later files another suit to cancel the same deed, claiming fraud. The second suit is barred by residential judicata. However, even if the second suit were framed differently, it might also be barred under Article 59 if filed after 3 years from when the fraud became known. Landmark case laws. Der LL.B. State of UP, 1961, in Der LL.B. State of UP, Air 1961 SC 1457, the Supreme Court elucidated the scope of residential judicata. The petitioners filed a writ petition under Article 32 of the Constitution after their earlier writ petition under Article 226 was dismissed by the Allahabad High Court. The Supreme Court held that the dismissal of the earlier petition on merits constituted residential judicata barring the subsequent petition. The court emphasized that residential judicata applies to writ proceedings, provided the earlier decision was by a competent court and on merits. 12. This case established that residential judicata is not limited to civil suits but extends to constitutional remedies, reinforcing its wide applicability. Sidiat Hyan Gosal v. D. Origin Debi, 1960, in Sidiat Hyan Gosal v. D. Origin Debi, Air 1960 SC 941, the Supreme Court clarified the concept of constructive residential judicata. The case involved a landlord-tenant dispute where the tenant failed to raise certain defenses in the first suit. In a subsequent suit, the tenant attempted to raise those defenses. The court held that the tenant was barred by constructive residential judicata because the defenses could have been raised in the earlier suit. This case underscores the importance of consolidating all claims and defenses in one proceeding. Shiadan Singh v. Yeo Kunwar, 1966, in Shiadan Singh v. Yeo Kunwar, Air 1966 SC 1332, the Supreme Court held that residential judicata applies only when the former suit is decided on merits. If a suit is dismissed for technical reasons, such as non-joinder of parties or lack of jurisdiction, residential judicata does not apply. This case highlights a key limitation of the doctrine, emphasizing the requirement of a merits-based decision. Limitations of residential judicata: non-applicability to incompetent courts. For residential judicata to apply, the earlier decision must be by a court of competent jurisdiction. If the court lacked jurisdiction, its decision does not bind the parties. For example, if a small cause court decides a title dispute beyond its jurisdiction, a subsequent suit in a competent court is not barred. No application to dismissals on technical grounds as held in Shiadan Singh v. Yeo Kunwar. Dismissals for procedural or technical reasons, such as non-payment of court fees or non-joinder of necessary parties, do not attract residential judicata. The parties can file a fresh suit after rectifying the defect. Different causes of action: if the subsequent suit involves a different cause of action, residential judicata does not apply. For instance, if A sues B for breach of contract and loses, A can still sue B for a tort arising from the same transaction, as the causes of action are distinct. Illustration: A sues B for non-delivery of goods under a contract, and the suit is dismissed. Later, A sues B for fraud in inducing the contract. The second suit is not barred because the cause of action, fraud, differs from the first, breach of contract. 13. Fraud or collusion: if the earlier decision was obtained by fraud or collusion, residential judicata does not apply. For example, if A obtains a decree against B by suppressing material facts, B can challenge the decree in a fresh suit, as held in A.V. Papayasastri v. Government of AP, 2007, 4 SCC 221. Change in law: a change in the legal position due to new legislation or judicial interpretation may render residential judicata inapplicable. For instance, if a court's decision is based on a law later declared unconstitutional, a fresh suit may be maintainable. Interplay with Limitation Act, 1963. The Limitation Act, 1963, complements residential judicata by imposing temporal restrictions on litigation. While residential judicata prevents relitigation of decided matters, the Limitation Act ensures that even new claims are filed within prescribed periods. For example, under Article 58, a suit for a declaration must be filed within 3 years from when the right to sue accrues. Under Article 65, a suit for possession of immovable property based on title has a limitation period of 12 years. If a party attempts to circumvent residential judicata by framing a new suit, the Limitation Act may still bar it if filed beyond the prescribed time. In State of Punjab v. Gurdev Singh, 1991, 4 SCC 1, the Supreme Court held that a suit barred by limitation cannot be entertained, even if residential judicata does not apply, emphasizing the interplay between the two statutes. Practical implications and challenges: the doctrine of residential judicata is instrumental in Indiana maintaining judicial discipline but poses challenges in complex litigation. Litigants may attempt to bypass residential judicata by framing new causes of action. Oregon alleging fraud, which requires courts to carefully scrutinize the substance of claims. Additionally, determining whether an issue was directly and substantially an issue can be contentious, especially in cases involving multiple issues. Courts must also balance the doctrine's application with access to justice. Overly rigid application may deny a party a fair hearing, particularly in cases of fraud or jurisdictional errors. Conversely, lax application may encourage vexatious litigation, undermining the doctrine's purpose. 14. Question 4. Describe in detail the law relating to place of filing a civil suit. Describe in detail the law relating to place of filing a civil suit. General principles of territorial jurisdiction. Territorial jurisdiction determines the geographical location of the court where a civil suit must be filed. The CPC categorizes suits based on the nature of the subject matter and the cause of action, ensuring that the court has a logical connection to the dispute. Sections 15 to 20 of the CPC govern this aspect, with Section 15 establishing a fundamental rule: every suit shall be instituted in the court of the lowest grade competent to try it. This principle promotes judicial efficiency by ensuring that lower courts handle cases within their pecuniary and subject matter jurisdiction, reserving higher courts for appeals or complex matters. Section 16 to 20 further specify the appropriate court based on the nature of the suit, the location of the property, or the parties involved. Key provisions. The CPC provides a structured approach to determining the place of suing, as follows. Section 15, suits must be filed in the court of the lowest grade competent to try them, subject to pecuniary and subject matter jurisdiction. Section 16, suits related to immovable property must be filed in the court within whose jurisdiction the property is situated. Section 17, suits concerning immovable property situated within the jurisdiction of different courts may be filed in any of those courts. Section 18, if the jurisdiction is uncertain, the court where the suit is filed may proceed if the parties acquiesce or if the uncertainty is resolved. Section 19, suits for compensation for wrongs to person or movable property may be filed where the wrong was done or where the defendant resides or carries on business. Section 20, all other suits may be filed where the cause of action arises, wholly or in part, or where the defendant resides, carries on business, or personally works for gain. These provisions collectively ensure that the place of suing is determined based on the nature of the dispute, the location of the subject matter, or the convenience of the parties. Suits relating to immovable property. Sections 16 and 17 of the CPC specifically address suits involving immovable property, such as disputes over title, possession, or rights to land, buildings, or other immovable assets. 15. Section 16, jurisdiction based on property location. Section 16 mandates that suits concerning immovable property be filed in the court within whose territorial jurisdiction the property is situated. This section covers recovery of immovable property, e.g., possession or title disputes, partition of immovable property, foreclosure, sale, or redemption of mortgaged property, determination of any right or interest in immovable property, compensation for wrongs to immovable property, e.g., trespass. The rationale is that the court closest to the property is best equipped to adjudicate disputes, as it facilitates evidence collection, site inspections, and enforcement of decrees. Example: A files a suit against B to recover a house located in Jaipur, Rajasthan, claiming ownership based on a sale deed. The suit must be filed in a civil court in Jaipur, as per Section 16, since the immovable property is situated there. Section 17, multiple jurisdictions. Section 17 provides flexibility when immovable property is situated within the jurisdiction of different courts. In such cases, the plaintiff may file the suit in any court within whose jurisdiction a portion of the property lies, provided the entire claim is cognizable by that court. Example: A owns a large estate spanning the jurisdictions of two courts in Delhi and Gurugram. A files a suit for partition of the estate. Under Section 17, A may file the suit in either Delhi or Gurugram, provided the court has the requisite jurisdiction to handle the entire claim. Leading case: Harshad Chiman Lal v DLF Universal Ltd. In Harshad Chiman Lal v DLF Universal Limited, Air 2005 SC 4446, the Supreme Court clarified the application of Section 16. The case involved a dispute over a property purchase agreement, where the plaintiff sought specific performance. The property was located in Gurgaon, but the agreement was executed in Delhi. The court held that since the suit directly related to immovable property, specific performance of a sale agreement, it must be filed in the court where the property was situated, Gurgaon, as per Section 16. The court emphasized that Section 16 is mandatory for suits directly affecting immovable property, underscoring the importance of territorial proximity. Suits for wrongs to person or movable property. Section 19 addresses suits for compensation for wrongs to a person, e.g., personal injury, defamation, or movable property, e.g., damage to goods. Such suits may be filed, where the wrong was committed, where the defendant resides, carries on business, or personally works for gain. 16. This provision provides plaintiffs with flexibility, allowing them to choose a forum based on the location of the incident or the defendant's residence. Example, A files a suit against B for damages due to a car accident in Kolkata, where B resides in Mumbai. A may file the suit in Kolkata, where the wrong occurred, or Mumbai, where the defendant resides, as per Section 19. Case law, Union of India v. Lajalal Jain. In Union of India v. Lajalal Jain, Air 1963 SC 1681, the Supreme Court addressed a suit for damages against the railways for loss of goods during transit. The plaintiff filed the suit in Assam, where the goods were lost, although the defendant, railways, operated across multiple jurisdictions. The court upheld the filing in Assam under Section 19, as the wrong, loss of goods, occurred there, illustrating the application of territorial jurisdiction based on the place of the cause of action. Other suits. Section 20. Section 20 is a residuary provision that applies to suits not covered by Section 16 to 19, such as contractual disputes, recovery of debts, or suits for injunctions not involving immovable property. It provides two primary options for filing, where the cause of action, wholly or in part, arises, where the defendant resides, carries on business, or personally works for gain. If there are multiple defendants, the suit may be filed where any one of them resides or carries on business, provided leave of the court is obtained or the defendants acquiesce. Cause of action. The cause of action refers to the bundle of facts that gives rise to the right to sue. It may include the place where a contract was made, performed, or breached, or where a tortious act occurred. Section 20 allows flexibility, as the cause of action may arise in multiple locations. Example, A enters into a contract with B in Chennai for the supply of goods to be delivered in Bangalore. B breaches the contract by failing to deliver. A may file a suit in Chennai, where the contract was made, or Bangalore, where the breach occurred, as per Section 20. Leading case, ABC Laminart Private Limited v. AP Agencies. In ABC Laminart Private Limited v. AP Agencies, Air 1989 SC 1239, the Supreme Court provided a definitive interpretation of cause of action under Section 20. The case involved a contract dispute where the agreement was executed in Salem, but the goods were to be supplied in Gujarat. The plaintiff filed the suit in Salem, claiming that the cause of action arose there due to the contract's formation. The court held that the cause of action includes every fact necessary to establish the plaintiff's right to relief, such as the place of contract formation, performance, or breach. The suit was maintainable in Salem, as part of the cause of action. Contract formation arose there. 17 Additional provisions and exceptions. Section 18, Uncertain jurisdiction. Section 18 applies when there is uncertainty about which court has territorial jurisdiction, such as when the boundaries of property are disputed. The court where the suit is filed may proceed if the parties do not object or if the uncertainty is resolved. Example, A files a suit for recovery of land whose exact location is disputed between two districts. If A files in one district's court and B does not object, the court may proceed under Section 18. Agreement on jurisdiction. Parties may agree to submit disputes to a specific court through a contractual clause, provided the chosen court has some connection to the cause of action or parties. Such agreements are valid under Section 20, subject to not ousting the jurisdiction of other competent courts entirely. Case law, Hakam Singh v. Gammon, India, Limited, Air 1971 SC 740. The Supreme Court upheld a clause in a contract that designated Bombay as the exclusive jurisdiction for disputes, even though part of the cause of action arose elsewhere. The court ruled that such agreements are valid if the chosen court has a nexus with the dispute and does not violate public policy. Interplay with the Limitation Act, 1963. The Limitation Act, 1963 prescribes time limits for filing civil suits, which must be adhered to regardless of the place of suing. Section 3 mandates that suits filed beyond the prescribed period are liable to be dismissed, even if the defendant does not raise limitation as a defense. The schedule to the Act specifies limitation periods, such as 3 years for suits for recovery of money, Article 113. 12 years for suits for possession of immovable property, Article 65. Example, A seeks to recover a debt from B, due in 2020, with the cause of action arising in Delhi. A files the suit in 2025 in a Delhi court with proper territorial jurisdiction. However, under Article 19, the limitation period is 3 years, and the suit is time-barred unless an exception, e.g., acknowledgement under Section 18, applies. Case law, State of Punjab v. Gurdev Singh. In State of Punjab v. Gurdev Singh, Air 1991 SC 2219, the Supreme Court emphasized that the Limitation Act is a statute of repose, designed to prevent stale claims. Even if a suit is filed in the correct court under Section 20, it must comply with the limitation period, or it risks dismissal. 18 Practical implications and analysis. The rules governing the place of filing a civil suit under Sections 15 to 20 of the CPC ensure that disputes are adjudicated by courts with a logical connection to the subject matter or parties. Section 16 prioritizes proximity for immovable property disputes, while Section 20 provides flexibility for other suits, reflecting the balance between judicial efficiency and litigant convenience. Landmark cases like ABC Laminart and Harshad Chiman Lal illustrate the judiciary's approach to interpreting cause of action and territorial jurisdiction, ensuring clarity and fairness. The Limitation Act, 1963 complements these provisions by imposing time constraints, preventing undue delays in litigation. For law students, understanding these rules is essential for advising clients on the appropriate forum and ensuring compliance with procedural requirements. Missteps in choosing the place of suing can lead to objections under Order 7 Rule 11 of the CPC, resulting in rejection of the plaint. Illustration, suppose A resident of Mumbai, enters into a contract with B, a resident of Kolkata, for services to be performed in Delhi. B breaches the contract, and A seeks specific performance. A may file the suit in Mumbai, where A resides, Kolkata, where B resides, or Delhi, where the cause of action arose, per Section 20. However, A must file within 3 years from the breach, Article 54, or the suit will be time-barred. 19 Question 5, state those properties, which cannot be attached and sold in the execution of money decree. State those properties, which cannot be attached and sold in the execution of money decree. Section 60, 1, of the CPC, along with its provisos, enumerates properties that cannot be attached or sold in execution of a money decree. These exemptions aim to protect the judgment debtor's basic needs, livelihood, and social obligations. The following is a detailed analysis of these properties. 1. Necessary wearing apparel, cooking vessels, beds, and bedding. These include clothing, utensils, and basic household items essential for daily living. For example, a judgment debtor's clothes, kitchen utensils, and bedding cannot be attached, as they are vital for personal use. 2. Tools of artisans, tools used by artisans for their trade, such as a carpenter's saw or a tailor's sewing machine, are exempt to protect their livelihood. For instance, in a case where a carpenter owes 5,000 under a money decree, his carpentry tools cannot be attached. 3. Implements of husbandry, agricultural implements used by a cultivator, such as plows or sickles, are exempt if the cultivator depends on them for livelihood. This ensures that farmers are not stripped of their means of sustenance. 4. Houses and buildings of agriculturists, laborers, or domestic servants, the house or building occupied by an agriculturist, laborer, or domestic servant, along with its appurtenant land, is exempt if they depend on it for their livelihood. For example, a farmer's dwelling house, used as his primary residence, cannot be attached. 5. Wages of laborers and domestic servants. Wages, whether payable in money or kind, are exempt to ensure that low-income workers are not deprived of their earnings. For instance, the monthly wages of a domestic worker cannot be attached. 6. Salaries and allowances. The salary of a public officer or servant, government or private, is exempt to the extent of the first 1,000 and 2/3 of the remainder, as per the 2005 amendment. The entire salary for the first 2 months after attachment. For example, if a government employee's monthly salary is 3,000, only 9,667, 1/3 of 2,9000, after exempting the first 1,000, can be attached. 7. Pensions and gratuities. Pensions of government servants and gratuities, e.g., Provident Fund amounts, are wholly exempt. For instance, a retired government teacher's pension cannot be attached to satisfy a money decree. 8. Compulsory deposits in Provident Funds. Deposits in Provident Funds under the Provident Funds Act, 1925, are exempt to secure the judgment debtor's financial future. 29. Money payable under life insurance policies. Amounts due under life insurance policies are exempt, protecting the judgment debtor's family's financial security. 10. Allowance declared exempt by the government. Any allowance notified by the central or state government as exempt, e.g., dearness allowance, cannot be attached. 11. Stipends and gratuities to pensioners. Stipends or gratuities granted to pensioners of the government or local authorities are exempt. 12. Expectancy of succession or promotion. The judgment debtor's potential inheritance or promotion prospects cannot be attached, as they are not vested rights. 13. Right to future maintenance. A right to maintenance, such as alimony, is exempt to ensure the recipient's sustenance. 14. Personal service contracts. Rights arising from contracts for personal service cannot be attached, as they are non-transferable. 15. Property under trust for public purpose. Property held in trust for a public purpose of a charitable or religious nature is exempt. 16. Books of account. Account books of a business are exempt, as they are not considered property with intrinsic monetary value. The provisos to Section 60, 1, clarify that the exemptions for houses and buildings apply only to agriculturists, laborers, or domestic servants who depend on them for livelihood. The exemption for salaries and wages is subject to the monetary limits specified. Certain properties, e.g., stipends, may be attachable in specific cases, such as for maintenance decrees. Landmark case laws. The judiciary has significantly shaped the interpretation of Section 60, 1, exemptions through landmark judgments. Below are key cases: Union of India v. Hira Devi, Air 1952 SC 227. In this case, the Supreme Court clarified the exemption of Provident Fund amounts under Section 60, 1, K. The court held that compulsory deposits in a Provident Fund, governed by the Provident Funds Act, 1925, are wholly exempt from attachment, as they are intended to secure the employee's future. The case involved a railway employee whose Provident Fund was sought to be attached to satisfy a money decree. The court ruled that such funds are protected to prevent destitution. 21. This case underscores the protective intent of Section 60, 1, emphasizing that exemptions prioritize the judgment debtor's long-term financial security over the decree holder's immediate recovery. Sawarni v. Inderkaur, 1996, 6 SCC 223. The Supreme Court in this case addressed the exemption of a residential house under Section 60, 1, c. The court held that the house of an agriculturist is exempt only if it is occupied by them and necessary for their livelihood. In this case, the judgment debtor, an agriculturist, resided in the house, which was his sole residence. The court ruled that the house could not be attached, reinforcing the humanitarian aspect of the exemption. This case highlights the conditional nature of exemptions for houses, requiring proof of occupation and dependency, and illustrates the balance between decree enforcement and debtor protection. Apasehe v. Balchandra, Air 1961 SC 589, this case clarified the exemption of agricultural implements and houses under Section 60, 1, B, and C. The Supreme Court held that implements used by an agriculturist for farming, such as plows and bullocks, are exempt if they are essential for their livelihood. The court also emphasized that the exemption applies only to agriculturists actively engaged in cultivation, not to those who lease their land. This case delineates the scope of exemptions for agricultural tools and houses, ensuring that only those genuinely dependent on such properties benefit from the protection. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, governs the time frame for executing a money decree. Under Article 136, a decree holder has 12 years from the date the decree becomes enforceable to apply for execution, including attachment and sale of property. However, the exemptions under Section 60, 1, limit the properties available for execution, requiring the decree holder to identify attachable assets within this period. In this case, the Madhya Pradesh High Court held that the limitation period for execution begins when the decree becomes enforceable, which may be delayed by appeals or stays. The case involved a money decree where the decree holder sought to attach the judgment debtor's salary, but the court protected the exempt portion under Section 60, 1, I, emphasizing the interplay between CPC exemptions and limitation periods. Practical examples to illustrate the application of Section 60, 1, exemptions, consider the following scenarios. 1. Carpenter's tools. A carpenter owes 100,000 under a money decree. The decree holder seeks to attach his carpentry tools, e.g., saws, hammers. Under Section 60, 1, B, these 22 tools are exempt, as they are essential for his livelihood. 2. Agriculturist's house. A farmer, residing in his ancestral home, faces a money decree of 500,000. The decree holder attempts to attach the house. Under Section 60, 1, C, the house is exempt if the farmer occupies it and depends on it for his livelihood. 3. Government employee's salary. A government employee with a monthly salary of 500,000 owes 200,000. The decree holder can attach only 15667, 1/3 of 49000, after exempting 1000, under Section 60, 1, I, and the first 2 months' salary is wholly exempt. 4. Provident Fund. A retired employee's provident fund of 100,000 is sought to be attached. Under Section 60, 1, K, the entire amount is exempt, protecting the retiree's financial security. 23. Question 6. In what manner and under which circumstances commission can be issued? Explain the powers of commissioner. In what manner and under which circumstances commission can be issued? Explain the powers of commissioner. Legal framework for issuance of a commission. Provisions under the CPC. The issuance of a commission is governed by Sections 75 to 78 and Order XXVI of the CPC. Section 75 empowers a court to issue a commission for various purposes, subject to conditions prescribed by the rules. These purposes include: a. Examining witnesses who cannot attend court. b. Conducting local investigations. c. Making partitions of property. d. Performing ministerial acts. e. Holding scientific, technical, or expert investigations. f. Conducting sales of property under court orders. g. Examining accounts. Order XXVI provides detailed rules for issuing commissions, specifying the circumstances and procedures for each purpose. The court has discretion to issue a commission, but such discretion must be exercised judicially, considering the case's facts and circumstances. Interplay with the Limitation Act, 1963. While the CPC governs the procedural aspects of issuing a commission, the Limitation Act, 1963, may apply to the filing of suits or applications where a commission is sought. For instance, under Article 113 of the Limitation Act, a suit for which no specific limitation period is prescribed must be filed within 3 years from when the right to sue accrues. If a party seeks a commission in a suit filed beyond this period, the court may reject the suit or application, rendering the request for a commission moot. Additionally, applications for commissions in execution proceedings, e.g., for partition under Order XXVI, Rule 13, must align with the limitation period for execution under Article 136, 12 years from the date the decree becomes enforceable. Circumstances for issuing a commission: examination of witnesses, Order XXVI, Rules 1-8, a commission may be issued to examine witnesses who are unable to attend court due to illness, infirmity, residence beyond the court's jurisdiction, or other sufficient reasons. This includes 24 persons residing outside India. Persons exempted from personal appearance, e.g., women under purdah, as per Section 132. Public servants or persons whose absence would cause public inconvenience. Illustration: A files a suit against B in Delhi, but a key witness, C, resides in London and cannot travel due to health issues. A applies for a commission to examine C in London. The court, satisfied with the reasons, issues a commission to a local advocate or court in London to record C's testimony. The court may issue a commission suo motu or on the application of a party, provided the application is made in good faith and not to delay proceedings. In SMT Sarla Devi v Balwant Singh, Air 1969 All 601, the court emphasized that a commission for witness examination should not be issued if the witness can be summoned to court without undue hardship. Local investigation, Order XXVI, Rules 9-10, a commission for local investigation is issued when the court requires an on-site inspection to clarify facts, such as determining property boundaries, assessing damages, or verifying physical conditions. The commissioner submits a report, which is admissible as evidence but subject to challenge by the parties. Illustration: in a dispute over a boundary between two properties, A and B disagree on the demarcation line. The court appoints a surveyor as a commissioner to inspect the site, measure the boundaries, and submit a report with a map. The report aids the court in resolving the dispute. In Debendranath v Nathabwiyan, Air 1973 Ori 240, the Orissa High Court held that a local investigation commission should be issued only when the court cannot resolve the issue based on existing evidence, emphasizing judicial discretion. Partition of property, Order XXVI, Rules 13-14, in suits for partition of immovable property, the court may issue a commission to effect the division of property according to the parties' shares, especially when physical inspection is necessary. Illustration: A, B, and C inherit a joint family property. A files a suit for partition, and the court decrees equal shares. To physically divide the property, the court appoints a commissioner to inspect the property, propose a division plan, and submit a report. Scientific, technical, or expert investigation, Order XXVI, Rule 10A, when a suit involves complex scientific or technical issues, the court may appoint an expert as a commissioner to investigate and report findings. This is common in cases involving patent disputes, environmental damage, or structural assessments. Illustration: in a patent infringement suit, the court appoints an engineer as a commissioner to examine the defendant's product and determine if it violates the plaintiff's patent. The commissioner's report forms a critical part of the evidence. 25 Ministerial Acts and Sale of Property, Order XXVI, Rules 11-12, commissions may be issued for ministerial acts, such as examining accounts in partnership disputes, or for conducting sales of property under court orders, particularly in execution proceedings. Illustration: in an execution proceeding, the court decrees the sale of a debtor's property to satisfy a debt. A commissioner is appointed to conduct the auction, ensuring compliance with court orders. Powers of a commissioner. The powers of a commissioner are derived from the court's order and the provisions of Order XXVI. These powers vary depending on the purpose of the commission but are generally limited to the tasks specified in the commission's warrant. The key powers include, powers in witness examination under Order XXVI, Rule 1618, a commissioner appointed to examine witnesses has the following powers: administer oaths to witnesses. Record evidence, including oral testimony and documents produced. Compel attendance of witnesses and production of documents, similar to a court's powers under Order 16. Examine witnesses in private, if directed by the court, e.g., for women exempted under Section 132. The commissioner's proceedings are deemed judicial proceedings, and the evidence recorded is admissible in court, subject to objections regarding its admissibility or relevance. Illustration: a commissioner appointed to examine a bedridden witness administers an oath, records the testimony, and ensures the witness produces relevant documents. The commissioner submits the recorded evidence to the court, which the parties may challenge during the trial. In Padmalochan v. State of Orissa, Air 1971 Ori 217, the court held that a commissioner's power to examine witnesses is quasi-judicial, and the evidence recorded is subject to the same scrutiny as court-recorded evidence. Powers in local investigation. A commissioner appointed for local investigation under Order XXVI, Rule 9, has the power to visit and inspect the site or property in question. Take measurements, photographs, or sketches as necessary. Examine witnesses or local residents to gather relevant information. 26. Prepare and submit a detailed report with findings. The report is not binding but serves as evidence, which the court may accept or reject after hearing objections. In Ramnarayan v. State of UP, Air 1984 SC 1213, the Supreme Court clarified that a commissioner's report is not conclusive and must be corroborated by other evidence, emphasizing the court's supervisory role. Powers in partition and other ministerial acts. For partition, Order XXVI, Rule 13, the commissioner can inspect and measure the property. Propose a division plan based on the court's decree. Consult parties or their representatives to ensure fairness. For ministerial acts like examining accounts, Order XXVI, Rule 11, the commissioner may scrutinize financial records. Call for additional documents or clarifications. Submit a report summarizing the accounts. Limitations on commissioners' powers. While commissioners wield significant powers, they are subject to limitations. A commissioner cannot adjudicate disputes or pronounce judgments, as these are exclusive to the court. The commissioner's role is confined to the tasks specified in the court's order. The commissioner cannot act beyond the scope of the commission or exercise inherent judicial powers. The report or evidence submitted is subject to court scrutiny and party objections. In Sailendra Narayan v. State of Orissa, Air 1956 SC 346, the Supreme Court held that a commissioner's findings are not binding and must be evaluated by the court, reinforcing the principle that commissioners are delegates of the court, not independent adjudicators. Landmark Case Laws. SMT Sarla Devi v. Balwant Singh, Air 1969 All 601, this case clarified the circumstances for issuing a commission to examine witnesses. The court refused a commission for a witness who could attend court without significant inconvenience, emphasizing that commissions should not be used to delay proceedings or avoid cross-examination in court. 27. Devendranath v. Nathabwian, Air 1973 Ori 240, the Orissa High Court held that a commission for local investigation is warranted only when the court cannot resolve the issue based on existing evidence. The court stressed the need for clear reasons justifying the commission, balancing judicial efficiency with the need for accurate fact-finding. Ramnarayan v. State of UP, Air 1984 SC 1213, this case underscored the evidentiary value of a commissioner's report in local investigations. The Supreme Court ruled that while the report is admissible, it is not conclusive, and the court must evaluate it alongside other evidence, ensuring fairness to all parties. Padmalochan v. State of Orissa, Air 1971 Ori 217, the Orissa High Court clarified the quasi-judicial nature of a commissioner's role in examining witnesses, emphasizing that the evidence recorded is subject to the same legal standards as court-recorded evidence, including cross-examination and objections. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, does not directly govern the issuance of a commission but impacts the underlying suit or application. For example, in a suit for possession, Article 65, Limitation Act, a commission for local investigation must be sought within 12 years from when the right to sue accrues. In execution proceedings, Article 136, an application for a commission to effect partition or sale must be filed within 12 years from the decree's enforceability. In State of Punjab v. Gurdev Singh, 1991, 4 SCC 1, the Supreme Court held that a suit or application barred by limitation cannot proceed, even if a commission is sought to gather evidence. This underscores the need for timely filing to ensure the efficacy of a commission. Practical implications and challenges. The issuance of a commission enhances judicial efficiency by delegating specific tasks to qualified individuals, particularly in cases requiring on-site inspections or expert analysis. However, challenges include delay in proceedings. Parties may misuse commission applications to prolong litigation, necessitating strict judicial oversight. Cost implications. Appointing a commissioner involves expenses, which may burden litigants, especially in smaller cases. Scrutiny of reports. The non-binding nature of a commissioner's report requires courts to carefully evaluate its findings, which can complicate proceedings. Courts must balance the utility of commissions with the need to avoid abuse, ensuring that commissions serve the ends of justice without undue delay or expense. 28. Question 7. What is supplemental proceeding under Civil Procedure Code, 1908? What is supplemental proceeding under Civil Procedure Code, 1908? Concept of supplemental proceedings. Supplemental proceedings under the CPC refer to ancillary or auxiliary processes undertaken by a court to facilitate the effective administration of justice. These proceedings are not independent suits but are supplementary to the main action, aimed at preserving the subject matter of the dispute, preventing abuse of process, or ensuring compliance with court orders. They are typically invoked during the pendency of a suit or in the execution phase to address emergent needs that cannot wait for the final adjudication. The CPC does not explicitly define supplemental proceedings but provides for them under various provisions, particularly in Part 2, Execution, and Order XXXVIII to Order XL. These provisions empower courts to issue orders that safeguard the interests of parties, maintain the status quo, or ensure the enforceability of decrees. Objective supplemental proceedings serve several key objectives: prevention of injustice, to protect parties from irreparable harm during litigation, such as through temporary injunctions or attachment before judgment. Preservation of subject matter, to ensure the disputed property or rights remain intact until the suit is decided. Enforcement of court orders, to facilitate the execution of decrees through measures like arrest or attachment. Curbing abuse of process, to prevent frivolous or vexatious litigation by requiring security for costs. Types of supplemental proceedings. Supplemental proceedings encompass a range of measures under the CPC, each governed by specific provisions. The following sections explore the primary types, their legal basis, and their application. Arrest and attachment before judgment. Order XXXVIII of the CPC provides for arrest and attachment before judgment, measures designed to prevent defendants from obstructing justice by absconding or disposing of assets. 29. Arrest before judgment, Order XXXVIII, Rules 1-4, under Order XXXVIII, Rule 1. A court may order the arrest of a defendant before judgment if there is a reasonable apprehension that the defendant intends to leave the court's jurisdiction to avoid legal proceedings, obstruct or delay the execution of a decree, The plaintiff must demonstrate a prima facie case and provide security for any potential loss to the defendant. Arrest is a drastic measure and is used sparingly, typically when the defendant's conduct indicates an intent to evade justice. Example, A files a suit against B for recovery of Rs 50 lakhs. A learns that B is planning to flee to Dubai to avoid paying any potential decree. A applies for B's arrest under Order XXXVIII, Rule 1. If the court is satisfied, it may order B's arrest, subject to B furnishing security. Attachment before judgment, Order XXXVIII, Rules 5 to 13, Order XXXVIII, Rule 5 empowers courts to attach a defendant's property before judgment if there is evidence that the defendant is about to dispose of or remove the property to defeat the decree. The plaintiff must show, a prima facie case, that the defendant intends to obstruct or delay execution. Attachment may cover movable or immovable property, but the court ensures that only property sufficient to satisfy the potential decree is attached. Leading case, Mariva Compania Naviera SAB International Bulk Carriers SA, 1975, 2 Lloyds Rep 509, adopted in India. Although a foreign case, the principles of the Mariva injunction have influenced Indian jurisprudence on attachment before judgment. In Rajendran v Shankar Sundaram, Air 2008 SC 1170, the Supreme Court applied similar principles, upholding an attachment order where the defendant was transferring assets to defeat the plaintiff's claim. The court emphasized that attachment before judgment is a preventive measure to secure the ends of justice. Example, in a suit for recovery of money, A discovers that B is selling his properties to render himself judgment-proof. A applies for attachment of B's land under Order XXXVIII, Rule 5. If the court finds sufficient evidence, it may order attachment pending the suit's outcome. Temporary injunctions. Order XXXIX, Rules 1 and 2 of the CPC govern temporary injunctions, which are interim orders to maintain the status quo or prevent irreparable harm during the pendency of a suit. A court may grant a temporary injunction if there is a prima facie case in favor of the plaintiff. 30. The balance of convenience lies with the plaintiff. The plaintiff would suffer irreparable injury without the injunction. Temporary injunctions may restrain a party from committing an act, e.g., selling disputed property, or mandate an act, e.g., restoring possession. Leading case, American Cyanamid Co. v. Ethicon Limited, 1975, AC 396, adopted in India. The principles laid down in this case have been followed in India, notably in Gujarat Bottling Co. v. Coca-Cola Co., Air 1995 SC 2372. The Supreme Court held that the grant of a temporary injunction requires a prima facie case, balance of convenience, and irreparable harm. In this case, an injunction was granted to prevent the defendant from terminating a franchise agreement, as termination would cause irreparable loss to the plaintiff. Example, A files a suit claiming ownership of a plot of land, alleging that B is attempting to construct a building on it. A seeks a temporary injunction under Order XXXIX, Rule 1 to restrain B from constructing until the suit is decided. If A demonstrates a prima facie case and potential irreparable harm, the court may grant the injunction. Appointment of receivers. Order XL, Rule 1 empowers courts to appoint a receiver to manage, protect, or preserve property during the pendency of a suit. A receiver is an impartial officer of the court who takes custody of the disputed property to prevent its dissipation or mismanagement. The court may appoint a receiver if the property is in danger of being wasted, damaged, or alienated. It is just and convenient to do so. Receivers are commonly appointed in disputes involving partnership firms, trusts, or properties with multiple claimants. Case law, Krishna Kumar Khemka v. Grindlays Bank, Air 1990 SC 2152. The Supreme Court upheld the appointment of a receiver in a partnership dispute where one partner was mismanaging the firm's assets. The court emphasized that the appointment of a receiver is an equitable remedy to protect the interests of all parties. Example, in a suit for partition of a family business, A alleges that B is siphoning off profits. A applies for a receiver under Order XL, Rule 1. If the court finds evidence of mismanagement, it may appoint a receiver to manage the business until the suit is resolved. Security for Costs Order XXV, Rule 1 allows a court to order the plaintiff to furnish security for the defendant's costs if there is reason to believe the plaintiff may be unable to pay costs if the suit fails. This is common when the plaintiff is a foreigner, resides outside India, or is impecunious. Example, A non-resident Indian, files a suit against B in India. B applies under Order XXV, Rule 1, alleging that A lacks assets in India to cover costs if the suit is dismissed. The court may order A to deposit security for costs. 31 Other supplemental measures. Other supplemental proceedings include interlocutory orders, Order XXXIX, Rule 6 to 10 orders for sale of perishable goods or interim custody of property. Commissioners, Order XXVI appointment of commissioners for tasks like local inspections or recording evidence. Restitution, Section 144 restoring parties to their original position if a decree is reversed. Interplay with the Limitation Act, 1963. The Limitation Act, 1963 prescribes time limits for initiating legal proceedings, including applications for supplemental measures in certain cases. While supplemental proceedings are generally ancillary to a pending suit, some applications, e.g., restitution under Section 144, may have specific limitation periods. Relevant provisions. Section 3 bars applications filed beyond the prescribed period. Article 136 provides a 12-year limitation period for executing a decree, which may involve supplemental proceedings like attachment. Article 137 imposes a 3-year limitation for miscellaneous applications, e.g., restitution under Section 144, when no specific period is prescribed. Example, A obtains a decree in 2015, which is reversed in 2020. A applies for restitution under Section 144 in 2024. Under Article 137, the application is time-barred, as it exceeds the 3-year limit from the date of reversal. Case law, Mahajib Hai Mohan Bhai Barot v Patel Mani Bhai Gokal Bhai. In Mahajib Hai Mohan Bhai v Patel Mani Bhai Gokal Bhai, Air 1965 SC 1477, the Supreme Court held that applications for execution or restitution, or other proceedings must comply with the Limitation Act's time limits. The court dismissed an execution application for restitution, emphasizing that supplemental proceedings are subject to statutory time constraints. Practical implications and analysis. Supplemental proceedings under the CPC are vital tools for ensuring justice during litigation. They address emergent needs, such as preserving assets, preventing harm, or enforcing compliance, which cannot await the final adjudication of a suit's outcome. The discretionary nature of courts in granting measures like injunctions or receivers requires careful application, as seen in cases like 32 Gujarat Bottling and Rajendran. These cases highlight the judiciary's role in balancing equitable relief with procedural safeguards to prevent abuse. The Limitation Act, 1963, ensures that even supplemental proceedings are pursued diligently, preventing undue delays in ancillary applications. For law students, understanding these provisions is essential for advising clients on interim remedies and navigating execution challenges. Missteps in invoking supplemental proceedings, such as failing to demonstrate a prima facie case or missing limitation periods, can jeopardize a client's rights. Illustration: A files a suit against B for breach of contract involving a factory. During the suit, A learns that B is selling machinery to defeat the decree. A applies for attachment before judgment, Order XXXVIII, Rule 5, and a temporary injunction, Order XXXIX, Rule 1. If A proves a prima facie case and imminent harm, the court may grant both orders. If A later obtains a decree, execution proceedings under Section May 9 involve further supplemental measures, such as attachment of B's property, subject to the 12-year limitation period under Article 136. 33. Question 8, define and explain review. How does it differ from appeals? Define and explain review. How does it differ from appeals? Section 114 of the CPC provides for the review of judgments or orders by the court that pronounced them, subject to the conditions and limitations prescribed in Order 47, Rule 1. The term review is not explicitly defined in the CPC but is understood as a judicial re-examination of a case by the same court to correct errors apparent on the face of the record, discover new evidence, or address other sufficient reasons. Order 47, Rule 1 of the CPC states, any person considering himself aggrieved, a. by a decree or order from which an appeal is allowed, but no appeal has been preferred, b. by a decree or order from which no appeal is allowed, or, c. by a decision on a reference from a court of small causes, and who, from the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within his knowledge or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason, desires to obtain a review of the decree passed or order made against him, may apply for a review of judgment to the court which passed the decree or made the order. Review is a discretionary remedy that allows a court to revisit its own decision to rectify errors without requiring the matter to escalate to a higher court. It is an intra-court mechanism, distinct from appeals, which involve inter-court scrutiny. Review is not a routine procedure but an exceptional one, invoked only under specific grounds to prevent miscarriage of justice. Grounds for review. Order 47, Rule 1 specifies 3 primary grounds for seeking a review. 1. Discovery of new and important matter or evidence. The applicant must show that new evidence, which was not within their knowledge or could not be produced despite due diligence at the time of the original hearing, has come to light. This evidence must be material and likely to alter the outcome of the case. 2. Mistake or error apparent on the face of the record. The error must be evident from the record itself, without requiring elaborate arguments or re-examination of facts. For example, a misinterpretation of a statutory provision or a clerical error in the judgment qualifies as an error apparent. 3. Any other sufficient reason. This is a residuary ground, interpreted narrowly by courts to include reasons analogous to the first 2 grounds. It does not permit rehearing the case on merits or introducing new arguments. 34. An application for review must be made to the same court that passed the decree or order, as per Order 47, Rule 2. The application should be filed within the limitation period prescribed by the Limitation Act, 1963, under Article 124, which allows 30 days from the date of the decree or order. The court may grant a review after hearing the parties and may either confirm, modify, or set aside the original decree or order. Landmark case laws on review. The judiciary has clarified the scope and limitations of review through landmark judgments, emphasizing its restrictive nature. Shivdeo Singh v. State of Punjab, Air 1963 SC 1909, in this case, the Supreme Court elucidated the scope of review under Section 114 and Order 47. The court held that a review is permissible only for correcting errors apparent on the face of the record or for new evidence that could not have been produced earlier. In this case, the applicant sought a review of a High Court order dismissing a writ petition, citing a clerical error in the judgment. The Supreme Court allowed the review, emphasizing that the error was evident and did not require re-arguing the case. This case underscores the ground of error apparent on the face of the record, clarifying that review is not an appeal in disguise but a mechanism to correct patent mistakes. So Chandra Kanta v. Sheikh Habib, Air 1975 SC 1500, the Supreme Court in this case held that a review is not permissible to re-examine the correctness of the decision on merits or to introduce new arguments. The case involved a review application claiming that the court had misapplied a legal provision. The court rejected the review, stating that such issues fall within the domain of appeals, not reviews. This case highlights the restrictive nature of the sufficient reason ground, ensuring that reviews do not become a backdoor for relitigating cases. Mira Banja v. Nirmala Kumari Chowdhury, 1995, 1 SCC 170. In this case, the Supreme Court reiterated that a review is confined to errors apparent on the face of the record or new evidence of significant importance. The applicant sought a review of a decree dismissing a suit, citing a miscalculation in the evidence. The court rejected the review, holding that reappreciating evidence is beyond the scope of review and falls under appellate jurisdiction. This case reinforces the distinction between review and appeal, emphasizing that review is not a substitute for appellate scrutiny. Distinction between review and appeal. While both review and appeal are mechanisms to challenge judicial decisions, they differ significantly in scope, purpose, procedure, and effect. The following table summarizes the key distinct 35tions, criterion, definition, forum, grounds, scope, limitation period, objective examples. Review: a re-examination by the same court to correct errors apparent, discover new evidence, or address sufficient reasons, section 114, order 47. Same court that passed the decree or order. Limited to new evidence, error apparent, or sufficient reason, order 47, rule 1. Narrow, does not involve rehearing on merits. 30 days from the date of decree or order, Article 124, Limitation Act, 1963. Correct patent errors or incorporate new evidence without escalating to a higher court. Correcting a clerical error in a judgment or admitting new evidence not available earlier. Appeal: a re-examination by a higher court of a lower court's decision for substantive or procedural errors, sections 96-112. Higher court, e.g., High Court for District Court decrees. Broad, including errors of law, fact, or procedure, and reappreciation of evidence. Wide, allows re-examination of facts and law. 90 days to High Court, 30 days to other courts, Article 116, Limitation Act, 1963. Ensure correctness of lower court's decision through superior judicial scrutiny. Challenging a trial court's decree for misinterpretation of evidence or law. Table 1, Distinction between review and appeal. 1. Jurisdictional difference: review is an intra-court remedy, handled by the same judge or bench, ensuring minimal disruption to the judicial hierarchy. Appeals, however, involve a superior court, which has broader powers to re-evaluate the entire case. 2. Scope of scrutiny: review is limited to correcting patent errors or incorporating new evidence, as seen in Shivdeo Singh v. State of Punjab. Appeals, conversely, allow a comprehensive review of law and facts, as illustrated in Lachman Singh v. Hazara Singh, Air 2008 SC 2006, where the Supreme Court re-examined evidence in an appeal against a decree. 3. Grounds for application: review requires specific grounds under Order 47, Rule 1, such as errors apparent or new evidence. Appeals can be based on broader grounds, including errors of law, fact, or procedure, without such restrictive conditions. 4. Limitation periods: the Limitation Act, 1963, prescribes a shorter period for review, 30 days under Article 124, compared to appeals, 90 days to High Court under Article 116, reflecting the urgency of correcting patent errors. 5. Outcome: a successful review results in the modification or setting aside of the original decree by the same court. An appeal may lead to the decree being upheld, modified, or reversed by a higher court, with potential remand to the lower court. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, governs the time limits for seeking review and appeal, ensuring timely recourse to these remedies. Under Article 124, a review application must be filed within 30 days from the date of the decree or order. For appeals, Article 116 prescribes 90 days for appeals to the High Court and 30 days for other courts from the date of the decree. In this case, the Supreme Court emphasized that the limitation period for appeals begins from the date of the decree, not the date of knowledge, unless fraud or concealment is proven. Similarly, For reviews, the limitation period is strictly enforced, as seen in Board of Control for Cricket in India v Netaji Cricket Club, 2005, 4 SCC 741, where a delayed review application was dismissed for being time-barred. Practical examples to illustrate the application of review and its distinction from appeal: consider the following scenarios. 1. Review for error apparent. In a suit for partition, the court erroneously calculates the shares, e.g., 1/3 instead of 1/4 for a CO parsoner, due to a clerical mistake. The aggrieved party files a review application under Order 47, Rule 1, citing an error apparent on the face of the record. The same court corrects the mistake, modifying the decree. 2. Review for new evidence. In a money recovery suit, the defendant discovers a receipt proving payment after the decree is passed. The defendant applies for review, showing that the receipt was not available earlier despite due diligence. The court reviews the decree and sets it aside. 3. Appeal for substantive error. In a suit for specific performance, the trial court dismisses the suit, misinterpreting a contract clause. The plaintiff appeals to the High Court under Section 96, arguing that the court erred in law and fact. The High Court re-examines the evidence and reverses the decree. 4. Distinction in practice. If a party seeks to challenge a decree on the ground that the court misapplied a precedent, this is a matter for appeal, not review, as it involves re-arguing the case's merits, as clarified in Sauchandra Kanta v Sheikh Habib. 37. Question 9. Write a note on the aims and special features of the Limitation Act, 1963. Write a note on the aims and special features of the Limitation Act, 1963. Aims of the Limitation Act, 1963. The Limitation Act, 1963, serves multiple objectives, rooted in the principles of equity, justice, and judicial economy. The primary aims include: ensuring diligence in litigation. The Act encourages litigants to pursue their claims promptly, preventing undue delays that could prejudice the opposing party. By prescribing specific time limits for initiating legal proceedings, it ensures that claims are brought when evidence is fresh and witnesses are available, thereby facilitating fair adjudication. Illustration: A files a suit for recovery of a debt from B based on a promissory note executed in 2018. Under Article 19 of the Limitation Act, the limitation period for such a suit is 3 years from the date the note was executed. If A files the suit in 2025, it is barred by limitation, emphasizing the need for timely action. Providing repose and finality. The Act aims to provide repose to potential defendants by extinguishing claims after a specified period, ensuring that they are not perpetually vulnerable to litigation. This promotes legal certainty and stability in transactions. Illustration: A sells land to B in 2010, and B takes possession. In 2025, C claims ownership of the land, alleging fraud in the sale. Under Article 59, a suit to cancel an instrument due to fraud must be filed within 3 years from when the fraud became known. If C's claim is time-barred, B enjoys repose, free from the threat of litigation. Protecting judicial resources. By barring stale claims, the Act prevents courts from being overburdened with cases where evidence may have deteriorated or become unreliable. This aligns with the CPC's objective of expeditious justice under Section 89, which promotes alternative dispute resolution to reduce court congestion. Preventing abuse of legal process. The Act discourages vexatious or speculative litigation by imposing time limits, ensuring that only genuine and timely claims are entertained. This protects defendants from harassment through delayed or frivolous suits. 38. Balancing equity and justice. The Act balances the plaintiff's right to seek redress with the defendant's right to a fair defense. It acknowledges that delays can erode evidence, making it difficult for defendants to respond effectively, while also providing exceptions, e.g., for disability or fraud, to ensure equitable access to justice. In State of Punjab v Gurdev Singh, 1991, 4 SCC 1, the Supreme Court emphasized that the Limitation Act aims to protect defendants from indefinite liability while ensuring that genuine claims are not summarily dismissed due to procedural technicalities. Special features of the Limitation Act, 1963. The Limitation Act, 1963, incorporates several distinctive features that enhance its efficacy and flexibility in regulating the timeliness of legal proceedings. These features, supported by specific provisions, are analyzed below. Comprehensive schedule of limitation periods. The Act's schedule categorizes various legal proceedings, suits, appeals, and applications, and prescribes specific limitation periods under Articles 1 to 137. These periods vary depending on the nature of the claim, ranging from 30 days for certain appeals to 12 years for suits based on possession of immovable property. Examples: Article 58, a suit for a declaration, e.g., declaring a document void, must be filed within 3 years from when the right to sue accrues. Article 65, a suit for possession of immovable property based on title has a limitation period of 12 years from when possession becomes adverse. Article 116, an appeal to a high court under the CPC must be filed within 90 days from the date of the decree. This structured approach ensures clarity and uniformity in applying limitation periods across diverse legal actions. Computation of limitation period, Sections 1224. The Act provides detailed rules for computing the limitation period, ensuring fairness in determining when time begins to run and when it may be excluded. Key provisions include: Section 12 excludes the day from which the limitation period is computed and allows time for obtaining certified copies of judgments or decrees for appeals. Section 14 excludes time spent in prosecuting a proceeding in good faith in a court without jurisdiction, provided the plaintiff acted diligently. 39. Section 17 extends the limitation period in cases of fraud or concealment by the defendant, with time starting when the plaintiff discovers the fraud. Illustration: A files an appeal against a decree but spends 6 months pursuing it in a court lacking jurisdiction. Under Section 14, the time spent in the wrong court is excluded, allowing A to file the appeal in the correct court without being barred by limitation, provided good faith is established. In Consolidated Engineering Enterprises v. Principal Secretary, Irrigation Department, 2008, 7 SCC 169, the Supreme Court held that Section 14 applies only when the plaintiff demonstrates bona fide conduct and due diligence, underscoring the provision's equitable nature. Exceptions for disability, Section 6(8), the Act provides relief to persons under legal disability, such as minors, insane persons, or idiots, by extending the limitation period until the disability ceases or a guardian acts on their behalf. Section 6 allows such persons to file a suit within the prescribed period after the disability ends. Illustration: a minor, M, is entitled to file a suit for partition of ancestral property in 2015 when he turns 18. The limitation period under Article 65 is 12 years from when the right to sue accrues, say, 2010, when the property was alienated. M can file the suit until 2027, 12 years from 2015, as Section 6 extends the period due to his minority. Indershan Singh v. Gurdev Singh, 1994, 6 SCC 585, the Supreme Court clarified that the benefit of Section 6 is available only to the person under disability, not to their assignees or successors, emphasizing the provision's targeted application. Exclusion of time in certain cases. The Act allows exclusion of time in specific circumstances to prevent injustice. Section 15 excludes time during which a stay order or injunction prevents filing a suit or when notice is required under law, e.g., under Section 80 of the CPC for suits against the government. Section 17 extends the limitation period when the defendant's fraud or concealment prevents the plaintiff from discovering the cause of action. Illustration: A files a suit against a government entity but is required to serve a 2-month notice under Section 80 of the CPC. The limitation period under Article 58 is 3 years, ending on January 1, 2025. The 2-month notice period is excluded under Section 15, allowing A to file the suit by March 1, 2025. Condonation of delay, Section 5. Section 5 is a hallmark feature, allowing courts to condone delays in filing appeals or applications, but not suits, if the applicant shows sufficient cause for the delay. This discretionary power ensures that technicalities do not override substantive justice. 4D illustration, A files an appeal 100 days after a decree, exceeding the 90-day limit under Article 116. A explains the delay was due to hospitalization. The court, under Section 5, may condone the 10-day delay if satisfied with the cause. In Collector, Land Acquisition v. Kataiji, 1987, 2 SCC 107, the Supreme Court laid down liberal guidelines for condonation, emphasizing that courts should adopt a justice-oriented approach, considering factors like the length of delay, the explanation provided, and the potential prejudice to the parties. Continuous running of time, Section 9. Section 9 provides that once the limitation period begins, it runs continuously unless interrupted by a statutory exception, e.g., Sections 14, 15, or 17. This ensures predictability and prevents arbitrary extensions of time. Illustration, A's right to sue B for breach of contract accrues on January 1, 2022. The limitation period under Article 55 is 3 years, ending on January 1, 2025. Even if A negotiates with B for 2 years, the limitation period is not paused unless a statutory exception applies. Extinction of right, Section 27, a unique feature of the Act is Section 27, which extinguishes the right to property, not merely the remedy, if a suit for possession of immovable property is not filed within the prescribed period under Article 65, 12 years for private property, or Article 64, 30 years against the government. Illustration, A occupies B's land adversely from 2010. B fails to file a suit for possession by 2022, 12 years under Article 65. B's right to the property is extinguished, and A acquires title by adverse possession. In Pt Municha Canaretti v. Rivama, 2007, 6 SCC 59, the Supreme Court clarified that Section 27 extinguishes the owner's title upon expiry of the limitation period, vesting it in the adverse possessor, highlighting the Act's impact on substantive rights. Applicability to special and local laws, Section 29. Section 29 ensures that the Act applies to proceedings under special or local laws unless expressly excluded. This harmonizes limitation periods across various statutes, unless a specific law provides otherwise. Illustration, the Consumer Protection Act, 2019, does not prescribe a limitation period for filing complaints. Under Section 29, the Limitation Act's residuary Article 113, 3 years, applies to consumer complaints. Interplay with the Code of Civil Procedure, 1908. The Limitation Act, 1963, complements the CPC by setting temporal boundaries for procedural actions. For example, 41 filing of suits, under Section 20 of the CPC, suits must be filed in courts with territorial jurisdiction, but the Limitation Act governs the time within which they must be filed, e.g., Article 58 for declarations. Appeals and applications, the CPC's provisions for appeals, Order XLI, and applications, e.g., for injunctions under Order XXXIX, are subject to limitation periods under Articles 116, 117 and Section 5's condonation provision. Execution of decrees, under Section 48 of the CPC, repealed but relevant for pre-1963 decrees, and Article 136 of the Limitation Act, execution applications must be filed within 12 years from the decree's enforceability. In Shakuntala Devi v. Kuntal Kumari, Air 1969 SC 575, the Supreme Court held that the Limitation Act governs the time for filing applications under the CPC, such as for setting aside an ex parte decree, reinforcing the statute's interdependence. Landmark Case Laws Collector, Land Acquisition v. Kataiji, 1987, 2 SCC 107. This case established liberal principles for condonation of delay under Section 5, emphasizing that courts should prioritize substantial justice over technicalities. The court noted that even short delays, if reasonably explained, should be condoned to ensure a fair hearing. Pt. Munichikanareddy v. Rivama, 2007, 6 SCC 59. The Supreme Court clarified the effect of Section 27, holding that the expiry of the limitation period for recovering immovable property extinguishes the owner's title, vesting it in the adverse possessor. This underscores the Act's impact on substantive rights. State of Punjab v. Gurdef Singh, 1991, 4 SCC 1. The court emphasized the Limitation Act's role in providing repose and preventing stale claims, holding that a time-barred suit cannot be entertained, even if it involves significant issues, to protect defendants from indefinite liability. Consolidated Engineering Enterprises v. Principal Secretary, 2008, 7 SCC 169. This case clarified the application of Section 14, stressing that exclusion of time spent in a wrong court requires proof of good faith and diligence, balancing flexibility with accountability. Practical implications and challenges. The Limitation Act, 1963, is instrumental in maintaining discipline in litigation, but its application poses challenges. 42. Determining accrual of cause of action, identifying when the right to sue accrues can be contentious, especially in cases involving fraud or continuing wrongs. Condonation disputes, courts face challenges in assessing sufficient cause under Section 5, requiring a balance between leniency and fairness. Extinction of rights, Section 27's extinction of property rights can lead to harsh outcomes, necessitating careful judicial scrutiny to prevent injustice. Courts must interpret the Act's provisions liberally to ensure access to justice while preventing abuse through frivolous or delayed claims. 43. Question 10. Which time is excluded in computing the period of limitation? Explain with illustrations and relevant provisions of law. Which time is excluded in computing the period of limitation? Explain with illustrations and relevant provisions of law. Relevant provisions of the Limitation Act, 1963. The Limitation Act, 1963, under sections 12 to 15, outlines the circumstances under which certain periods are excluded from the computation of limitation. These provisions balance the strict application of limitation periods with equitable considerations, ensuring fairness in access to justice. Below is a detailed analysis of these provisions. Section 12. Exclusion of time in legal proceedings. Section 12 provides for the exclusion of time spent in certain procedural steps when computing the limitation period for suits, appeals, or applications. The key subsections include: Section 12, 1. The day on which the cause of action arises is excluded from the computation of the limitation period. For example, if a cause of action, e.g., breach of contract, occurs on January 1, 2025, the limitation period begins on January 2, 2025. Section 12, 2. In appeals or applications for leave to appeal, the time taken to obtain a copy of the decree, judgment, or order appealed against is excluded. This accounts for administrative delays in obtaining certified copies, which are prerequisites for filing appeals under the CPC. Section 12, 3. For applications to set aside an award, the time required to obtain a copy of the award is excluded. Section 12, 4. For applications for which no limitation period is prescribed, the time taken to obtain leave from the court is excluded. Illustration: suppose a plaintiff wishes to appeal a trial court's judgment dated March 1, 2025, and applies for a certified copy on March 2, 2025. The court issues the copy on March 10, 2025, and the appeal must be filed within 90 days under Article 116 of the Limitation Act. The period from March 2 to March 10, 9 days, is excluded, effectively extending the limitation period to account for this delay. Section 13, Exclusion of time in cases where leave to sue or appeal as a pauper is applied for. Section 13 excludes the time during which an application for leave to sue or appeal as an indigent person, pauper, is pending. Under Order 33 and Order 44 of the CPC, indigent persons may seek permission to proceed without paying court fees. The time taken by the court to decide such an application is excluded from the limitation period. 44 Illustration: a litigant applies for leave to appeal as an indigent person on April 1, 2025, and the court grants permission on April 15, 2025. If the appeal must be filed within 30 days, the 14 days spent on the application are excluded, extending the deadline accordingly. Section 14, Exclusion of time spent in proceedings bona fide in a court without jurisdiction. Section 14 excludes the time spent pursuing a case in a court that lacks jurisdiction, provided the proceedings were conducted in good faith and with due diligence. This provision protects litigants who mistakenly file cases in the wrong court due to jurisdictional complexities. Conditions for application: 1. The proceeding must have been prosecuted in good faith. 2. The proceeding must have been pursued with due diligence. 3. The court must have lacked jurisdiction due to a defect in jurisdiction or a cause of a like nature. 4. The proceeding must have failed due to this defect. Illustration: a plaintiff files a suit for recovery of property in a municipal court on January 1, 2025, believing it has jurisdiction. On March 1, 2025, the court dismisses the suit for lack of jurisdiction. The plaintiff then files the suit in the correct district court. The 2 months spent in the municipal court are excluded when computing the limitation period, provided the plaintiff acted in good faith and with due diligence. Section 15, Exclusion of time in certain cases. Section 15 provides for the exclusion of time in specific circumstances, such as, Section 15, 1 time during which a defendant is absent from India or a union territory where the suit is instituted. Section 15, 2 time during which an injunction or stay order prevents the institution of a suit or proceeding. Section 15, 3 time during which notice is required before filing a suit, e.g., under Section 80, CPC for suits against the government. Section 15, 4 time during which a receiver is appointed in insolvency proceedings. Section 15, 5 in cases of death of the plaintiff or defendant, the time taken to substitute legal representatives is excluded. Illustration: a plaintiff intends to sue the government and serves a mandatory notice under Section 80, CPC on January 1, 2025. The 2-month notice period ends on March 1, 2025. If the limitation period for the suit is 3 years, the 2 months spent on the notice are excluded, effectively extending the deadline. 45 Judicial interpretations and leading case laws. The judiciary has played a pivotal role in interpreting these provisions, ensuring their equitable application. Below are analyses of landmark cases that illustrate the application of Sections 12 to 15. Section 12, R.C. Jal Parsi v. Union of India, 1962, in R.C. Jal Parsi v. Union of India, Air 1962 SC 1281, the Supreme Court clarified the scope of Section 12, 2. The appellant sought to exclude the time taken to obtain a certified copy of a decree for filing an appeal. The court held that the time spent obtaining the copy, including the day of application and the day of issuance, is excluded, as these are procedural necessities under the CPC. The court emphasized that the exclusion applies only to the requisite time, i.e., the period reasonably required to obtain the copy. Analysis: this case underscores the importance of Section 12, 2, in ensuring that procedural delays do not prejudice litigants. The exclusion of time for obtaining certified copies aligns with Order 41, Rule 1 of the CPC, which mandates the submission of a decree copy with an appeal. Section 14, Madhavrao Narayanrao Patward Hanvi Ramrao Papatrao Shinda, 1962, in Madhavrao Narayanrao Patward Hanvi Ramrao Papatrao Shinda, Air 1962 SC 1368, the Supreme Court addressed the application of Section 14. The plaintiff had filed a suit in a court lacking jurisdiction, which was dismissed after 2 years. The plaintiff then filed a fresh suit in the correct court, seeking to exclude the time spent in the earlier proceeding. The court held that the plaintiff was entitled to the benefit of Section 14, as the initial proceeding was pursued in good faith and with due diligence. The court clarified that good faith implies an honest mistake, not negligence or mala fide intent. Analysis: this case highlights the equitable nature of Section 14, protecting litigants from jurisdictional errors. The requirement of good faith aligns with the principle that limitation laws should not penalize honest mistakes, provided due diligence is exercised. Section 15, State of Punjab v Shamlal Murari, 1976, in State of Punjab v Shamlal Murari, Air 1976 SC 1177, the Supreme Court interpreted Section 15, 3, in the context of Section 80, CPC. The plaintiff served a notice to the government before filing a suit, as required under Section 80. The court held that the 2-month notice period is excluded from the limitation period, as it is a statutory prerequisite for instituting the suit. The court emphasized that this exclusion ensures that procedural requirements do not curtail the substantive right to sue. Analysis: this case illustrates the interplay between the Limitation Act and the CPC, particularly in suits involving public authorities. The exclusion of the notice period under Section 15, 3, ensures that plaintiffs are not disadvantaged by mandatory procedural delays. 46. Interplay with the Civil Procedure Code, 1908. The CPC complements the Limitation Act by providing procedural mechanisms that align with the exclusion provisions. For instance, Order 41, Rule 1, CPC, requires a certified copy of the decree to accompany an appeal, justifying the exclusion under Section 12, 2. Order 33 and Order 44, CPC, govern applications for indigent status, supporting the exclusion under Section 13. Section 80, CPC, mandates a 2-month notice for suits against the government, necessitating the exclusion under Section 15, 3. This interplay ensures that procedural requirements under the CPC do not unduly restrict the rights protected by the Limitation Act. For example, the requirement of a certified copy under Order 41, Rule 1, directly correlates with the exclusion of time under Section 12, 2, ensuring that litigants are not penalized for delays beyond their control. Practical illustrations to further elucidate the application of these provisions: consider the following scenarios. 1 scenario under Section 12, 2. A plaintiff loses a case in a district court on January 10, 2025, and the limitation period for appeal is 90 days, Article 116. The plaintiff applies for a certified copy on January 11, 2025, and receives it on January 20, 2025. The 9 days, January 11 to January 20, are excluded, extending the appeal deadline to April 19, 2025, 90 days from January 20. 2 scenario under Section 14, a plaintiff files a suit for specific performance in a court lacking jurisdiction on February 1, 2023. The suit is dismissed on April 1, 2024, for lack of jurisdiction. The plaintiff files a fresh suit in the correct court on April 15, 2024. The 14 months spent in the wrong court are excluded, provided the plaintiff acted in good faith and with due diligence. 3 scenario under Section 15, 2. A plaintiff seeks to file a suit for recovery of property but is restrained by an injunction from January 1, 2025, to June 1, 2025. The 5-month period is excluded from the limitation period, allowing the plaintiff to file the suit after the injunction is lifted without losing the right to sue. Critical analysis: the exclusion provisions under the Limitation Act reflect a balance between the strict enforcement of limitation periods and the need to prevent injustice. By excluding time spent on procedural necessities, Section 12, jurisdictional errors, Section 14, or statutory requirements, Section 15, The Act ensures that litigants are not unfairly barred from seeking justice. However, the requirement of good faith and due diligence under Section 14 imposes a burden on litigants to act reasonably, preventing abuse of the provision. Judicial interpretations, such as in Madhavrao Paitwardhan, emphasize that these exclusions are not automatic but require scrutiny of the litigant's conduct. 47 Moreover, the interplay with the CPC highlights the procedural safeguards embedded in the Indian legal system. For instance, the mandatory notice under Section 80, CPC, while a procedural hurdle, is mitigated by the exclusion under Section 15, 3. However, challenges remain, such as determining what constitutes good faith or due diligence in complex cases, which may lead to inconsistent judicial outcomes. 48 Question 11, what is civil procedure? Explain the objects and rationale of Code of Civil Procedure. What is civil procedure? Explain the objects and rationale of Code of Civil Procedure. Understanding civil procedure. Civil procedure is the mechanism through which civil rights and obligations are enforced in courts. Unlike criminal procedure, which deals with offenses against the state, civil procedure addresses disputes between private parties or between individuals and the state in non-criminal matters. These disputes may involve contracts, property, torts, family law, or other civil wrongs. The CPC, 1908, provides a detailed roadmap for initiating, conducting, and concluding civil suits, covering aspects such as jurisdiction, pleadings, evidence, trial, judgment, and execution. Civil procedure serves as the backbone of the judicial process, ensuring that disputes are resolved in a manner that is just, equitable, and expeditious. It is designed to uphold the principles of natural justice, such as the right to a fair hearing, audi alteram partem, and the rule against bias. The CPC, with its 158 sections and 51 orders, lays down a comprehensive framework for civil litigation, while the Limitation Act, 1963, ensures that such litigation is initiated within prescribed time limits. Key features of the CPC, 1908. The CPC is divided into two parts, the sections, which contain substantive provisions, and the orders, which detail procedural rules. Key features include, jurisdiction. Sections 925 define the court's authority to hear cases based on subject matter, pecuniary value, and territorial limits. Pleadings. Order 6 governs the drafting of plaints and written statements, ensuring clarity in parties' claims and defenses. Trial. Orders 17xx outline the process of evidence, examination of witnesses, and arguments. Judgment and decree. Sections 33-35 and Order XX provide for the pronouncement and execution of judgments. Appeals and review. Sections 96-112 and Orders XLI-XLV allow parties to challenge decisions through appeals, revisions, or reviews. The Limitation Act, 1963, complements the CPC by prescribing time limits for filing suits, appeals, and applications. For instance, under Article 59, a suit to cancel or set aside an instrument must be filed within 3 years from the date the cause of action arises. 49 Objects of the Code of Civil Procedure, 1908. The CPC aims to provide a structured, efficient, and equitable framework for civil litigation. Its objects can be summarized as follows: 1. Facilitating justice. The CPC ensures that disputes are resolved based on substantive law, with procedural rules serving as a means to achieve justice, not an end in themselves. As observed in Sangram Singh v. Election Tribunal, Air 1955 SC 425, the CPC is a handmaid of justice, designed to aid the court in delivering fair outcomes. 2. Ensuring uniformity. By providing a standardized procedure, the CPC ensures consistency across courts in India, reducing arbitrariness and promoting predictability in judicial proceedings. 3. Promoting expedition. The CPC seeks to minimize delays in litigation through provisions like Order 8, Rule 1, which mandates timely filing of written statements. The 2002 amendments, upheld in Salem Advocate Bar Association v Union of India, Air 2005 SC 3353, introduced time-bound procedures to expedite case disposal. For protecting rights, the CPC safeguards parties' rights by ensuring due process, such as the right to be heard and the opportunity to present evidence. For example, Order 9 addresses the consequences of non-appearance and provides remedies like restoration of suits dismissed in default. 5. Reducing litigation costs, by streamlining procedures and encouraging alternative dispute resolution, ADR, under Section 89, the CPC aims to make justice accessible and affordable. Landmark case, Salem Advocate Bar Association v Union of India. In Salem Advocate Bar Association v Union of India, Air 2005 SC 3353, the Supreme Court upheld the 1999 and 2002 amendments to the CPC, which introduced provisions to reduce delays and promote efficiency. The case arose from challenges to amendments like Section 27, time-bound summons, and Order 8, Rule 1, 90-day limit for written statements. The court emphasized that the CPC's object is to ensure speedy justice without compromising fairness. It clarified that procedural timelines are directory, not mandatory, allowing courts discretion to balance efficiency with justice. This case underscores the CPC's rationale of adapting to modern judicial needs while preserving the principles of natural justice. The court's endorsement of ADR under Section 89 further highlights the CPC's goal of reducing judicial backlog and promoting amicable settlements. Rationale of the Code of Civil Procedure, 1908. The rationale of the CPC lies in its role as a procedural framework that supports substantive law, ensures fairness, and maintains judicial discipline. The following principles underpin its design. 51. Subordination to substantive law. The CPC is a procedural code that facilitates the enforcement of substantive rights under laws like the Indian Contract Act, 1872, or the Transfer of Property Act, 1882. In Premlata Agarwal v. Akshay Kumar, Air 1985 SC 889, the Supreme Court held that procedural laws must not defeat substantive rights unless explicitly provided. 2. Fairness and equity. The CPC ensures that both parties have an equal opportunity to present their case. Provisions like Order I, Joinder of Parties, and Order 2, Joinder of Causes of Action, prevent multiplicity of suits, ensuring comprehensive adjudication. 3. Judicial economy. By consolidating related disputes and providing mechanisms like residential judicata, Section 11, the CPC minimizes repetitive litigation, saving judicial resources. 4. Flexibility. The CPC allows courts to adapt procedures to specific cases through inherent powers under Section 151, ensuring justice in unforeseen circumstances. 5. Prevention of abuse. Provisions like Order 7, Rule 11, rejection of plaint, and Order XXI, execution of decrees, prevent frivolous litigation and ensure effective enforcement of judgments. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, reinforces the CPC's rationale by imposing time limits on legal actions, promoting diligence and finality. For example, Article 65 prescribes a 12-year limitation period for suits for possession of immovable property based on title. The Act ensures that parties do not sleep over their rights, as seen in State of Punjab v. Gurdap Singh, Air 1991 SC 2219, where the Supreme Court held that a suit filed beyond a limitation period is barred unless condoned under Section 5 of the Limitation Act. Section 5 allows courts to condone delays if sufficient cause is shown, reflecting the CPC's emphasis on justice over technicalities. In Collector, Land Acquisition v. Kaitaiji, Air 1987 SC 1353, the Supreme Court liberalized the approach to condonation, holding that courts should adopt a justice-oriented approach to avoid dismissing meritorious claims on procedural grounds. Landmark case, Anil Rai v. State of Bihar. In Anil Rai v. State of Bihar, 2001, 7 SCC 318, the Supreme Court addressed delays in pronouncing judgments, a critical aspect of the CPC's objective of expeditious justice. The court held that prolonged delays between hearing and judgment delivery violate the principles of fair trial and erode public confidence in the judiciary. It directed courts to adhere to Order XX, Rule 1, which mandates judgment delivery within 30 days of hearing, extendable to 60 days in exceptional cases. This case illustrates the CPC's rationale of ensuring timely justice and highlights the judiciary's role in upholding procedural discipline. It also reflects the interplay with the Limitation Act, as delays in judicial proceedings can impact parties' ability to enforce time-bound remedies. 51 Practical illustrations to elucidate the CPC's objects and rationale. Consider the following scenarios. 1. Contract dispute. A files a suit against B for breach of contract under Section 9 of the CPC. The Limitation Act prescribes a 3-year period for such suits, Article 55. If A files the suit after 4 years, B can plead limitation under Order 7, Rule 11, leading to rejection of the plaint unless A proves condonation under Section 5 of the Limitation Act. 2. Property dispute. C seeks possession of ancestral property from D, who claims adverse possession. Under Article 65 of the Limitation Act, C must file the suit within 12 years. The CPC's provisions on evidence, Order 18, allow C to prove title, while D can rely on residential judicata, Section 11, if a prior suit on the same issue was dismissed. 3. Frivolous litigation. E files a vexatious suit against F to harass him. F applies for rejection of the plaint under Order 7, Rule 11. The CPC's mechanism prevents abuse of process, aligning with its rationale of judicial economy. These examples demonstrate how the CPC and Limitation Act work together to ensure justice, efficiency, and fairness in civil litigation. 52 Question 12. Define decree and order and distinguish between them. Describe the types and ingredients of decree. Define decree and order and distinguish between them. Describe the types and ingredients of decree. Definition of decree under Section 2 of the CPC. A decree is defined as the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. It may be either preliminary or final. The definition further clarifies that a decree includes the rejection of a plaint, the determination of any question under Section 144, restitution, of the CPC. However, it excludes any adjudication from which an appeal lies as an appeal from an order. Any order of dismissal for default. A decree is thus a formal document that embodies the court's decision on the substantive rights of the parties involved in a suit. For instance, in a suit for recovery of property, a decree may declare the plaintiff's title to the property and direct the defendant to vacate it. Ingredients of a decree. For an adjudication to qualify as a decree under the CPC, it must satisfy the following essential ingredients. 1. Formal expression. The decision must be expressed formally, typically in writing, and must be pronounced by the court. This ensures clarity and enforceability. 2. Adjudication. There must be a judicial determination of the rights of the parties, involving the application of legal principles to the facts of the case. 3. Conclusive determination. The decision must conclusively settle the rights of the parties with respect to the matters in controversy, either wholly or in part. 4. Suit. The adjudication must arise from a suit, which is a proceeding initiated by the presentation of a plaint, Section 26, CPC. For example, in a suit for specific performance of a contract, the court's decision to direct the defendant to execute the sale deed in favor of the plaintiff constitutes a decree, as it conclusively determines the plaintiff's right to the property under the contract. 53. Definition of order. Section 2:14 of the CPC defines an order as the formal expression of any decision of a civil court which is not a decree. Orders encompass a wide range of judicial decisions that do not conclusively determine the substantive rights of the parties but address procedural or interlocutory matters. For instance, an order granting an interim injunction under Order 39, Rule 1 of the CPC is a decision that regulates the conduct of the parties pending the final adjudication of the suit but does not resolve the core dispute. Orders can arise in various contexts, such as procedural directions, e.g., granting an adjournment under Order 17. Interlocutory reliefs, e.g., temporary injunctions or appointment of a receiver. Decisions on preliminary issues, e.g., an order rejecting a plaint for non-payment of court fees. Distinction between decree and order. While both decrees and orders are formal expressions of a court's decision, they differ significantly in their scope, effect, and procedural implications. The following table outlines the key distinctions, criterion, definition, nature, appealability, number in a suit, execution. Examples. Table 2. Distinction between decree and order. Decree, order, formal expression of a judica, formal expression of a decision, conclusively determining the which is not a decree. Section Rights of Parties, Section 2, 14, CPC. CPC. Substantive, determining the procedural or interlocutory, reg rights of parties in the suit. Relating the conduct of the suit. Generally appealable as a mat, appealable only if specified unter of right under Section 96, der Section 104 or Order 43, CPC, unless barred. Rule 1, CPC. Typically one final decree, multiple orders may be passed though preliminary decrees may during the course of a suit exist in certain cases. Executable under Section 36, generally not executable unless CPC, as it determines substantive, assumes the character of additive rights. Decree, e.g., restitution under Section 144. Decree for specific performance, order for interim injunction, stay partition, or recovery of money. Of proceedings, or appointment of a receiver. For instance, in a suit for partition of joint family property, the court may pass a preliminary decree determining the shares of the parties, a decree under Section 2, and subsequently issue an order appointing a commissioner to effect the partition, an order under Section 2, 14. The decree addresses the substantive rights, while the order facilitates the procedural implementation of the decree. 54 types of decrees. The CPC recognizes 3 types of decrees, each serving a distinct purpose in the adjudication process. 1. Preliminary decree. A preliminary decree is passed in cases where the court determines the rights of the parties but leaves certain matters to be resolved in subsequent proceedings. It is not a final determination but a step towards it. For example, in a suit for partition, a preliminary decree declares the shares of the parties, while further proceedings determine the actual division of the property. Order 20, Rule 18, CPC. 2. Final decree. A final decree fully disposes of the suit by conclusively determining all matters in controversy. It is passed when no further adjudication is required. For instance, in a suit for recovery of money, the final decree specifies the amount to be paid by the defendant to the plaintiff. 3. Partly preliminary and partly final decree. In some cases, a decree may be partly preliminary and partly final. For example, in a suit for possession and mean profits, the court may pass a decree for possession, final, and direct an inquiry into mean profits, preliminary, as seen in Order 20, Rule 12, CPC. Examples of decrees. Partition suits. In a partition suit, a preliminary decree determines the shares of CO owners, while a final decree allocates specific portions of the property. Order 20, Rule 18. Mortgage suits. In a suit for foreclosure or sale of mortgaged property, a preliminary decree fixes the liability and grants time for redemption, while a final decree orders the sale or foreclosure. Order 34, CPC. Rejection of plaint. Under Order 7, Rule 11, the rejection of a plaint for reasons such as non-disclosure of a cause of action is deemed a decree under Section 2. Leading case law. The distinction between decree and order, as well as the application of decrees, has been clarified in several landmark judgments. Two notable cases are discussed below: Vidyacharan Shukla v. Kupchand Baghel, Air 1964 SC 1099. In this case, the Supreme Court elucidated the nature of a decree under Section 2(2) of the CPC. The court held that for an adjudication to qualify as a decree, it must conclusively determine the rights of the parties with regard to the matters in controversy. In this case, the dispute involved an election petition where the court's decision on the validity of the election was deemed a decree, as it conclusively determined the petitioner's right to challenge the election. The court emphasized 55 that the formal expression of adjudication is a critical ingredient of a decree, distinguishing it from interlocutory orders that do not finally settle the dispute. This case is significant for students as it underscores the importance of the conclusive determination criterion. For example, if a court dismisses an election petition for default, e.g., non-appearance of the petitioner, such a dismissal would not constitute a decree, as it lacks a conclusive determination of rights. Shankar Lal Agarwal v. Shankar Lal Poddar, Air 1965 SC 507, this case clarified the distinction between a preliminary and final decree in the context of a partition suit. The Supreme Court held that a preliminary decree determines the rights and shares of the parties, while a final decree is passed after the completion of ancillary proceedings, such as the division of property by metes and bounds. The court further noted that a preliminary decree is appealable under Section 97 of the CPC, ensuring that parties can seek redress against errors in the determination of their substantive rights. This case illustrates the practical application of preliminary decrees in complex suits requiring multiple stages of adjudication. For instance, in a suit for partition of a large estate, the court may pass a preliminary decree declaring the shares of CO owners and appoint a commissioner to propose a division, followed by a final decree confirming the allocation. Relevance of the Limitation Act, 1963. The Limitation Act, 1963, plays a crucial role in the context of decrees, particularly with respect to their execution and appeals. Under Section 3 of the Limitation Act, no suit, appeal, or application can be entertained if it is barred by limitation, even if the limitation defense is not raised by the opposite party. Key provisions relevant to decrees include: Article 136, the period of limitation for the execution of a decree, other than a decree granting a mandatory injunction, is 12 years from the date the decree becomes enforceable. Article 59, a suit to set aside a decree obtained by fraud must be filed within 3 years from the date the fraud becomes known to the plaintiff. Article 116, an appeal from a decree or order in a civil suit to a high court must be filed within 90 days from the date of the decree or order. For example, if a decree for recovery of money is passed on January 1, 2010, the decree holder must apply for execution by January 1, 2022, failing which the decree becomes time-barred under Article 136. Similarly, an appeal against a decree must be filed within 90 days, as seen in the case of Union of India v. West Coast Paper Mills Limited, Air 2004 SC 1596, where the Supreme Court held that delay in filing an appeal beyond the prescribed period could only be condoned under Section 5 of the Limitation Act if sufficient cause is shown. 56 practical illustrations to further elucidate the concepts. Consider the following hypothetical scenarios. 1. Decree in a money recovery suit. A plaintiff files a suit for recovery of 500,000 lent to the defendant. The court, after trial, passes a decree directing the defendant to pay the amount with interest. This is a final decree, as it conclusively determines the plaintiff's right to the money. If the defendant fails to comply, the plaintiff can seek execution under Section 36, CPC, within 12 years, Article 136, Limitation Act. 2. Order for interim injunction. In a property dispute, the plaintiff seeks an interim injunction to prevent the defendant from constructing on the disputed land. The court grants the injunction under Order 39, Rule 1. This is an order, not a decree, as it does not conclusively determine the ownership of the property. The order is appealable under Order 43, Rule 1, R, CPC. 3. Preliminary decree in a partition suit. In a suit for partition of a joint family property, the court declares that the plaintiff and defendant each have a 50% share. Preliminary decree. Subsequently, a commissioner is appointed to divide the property, and a final decree is passed confirming the division. Both decrees are subject to appeal under Section 96, CPC, within 90 days, Article 116, Limitation Act. 57. Question 13. What are suits of civil nature? Explain the general principles relating to jurisdiction of civil courts under the Code of Civil Procedure. What are suits of civil nature? Explain the general principles relating to jurisdiction of civil courts under the Code of Civil Procedure. Suits of a civil nature, definition and scope. Under Section 9 of the CPC, civil courts have jurisdiction to try all suits of a civil nature unless expressly or impliedly barred. A suit of a civil nature pertains to disputes involving private rights and obligations, as opposed to criminal or public law matters. The section reads, "The courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature excepting suits of which their cognizance is either expressly or impliedly barred." Characteristics of a suit of a civil nature. A suit of a civil nature typically involves private rights, disputes concerning property, contracts, torts, family matters, e.g., divorce, maintenance, or other civil rights. Legal remedies. The plaintiff seeks remedies such as damages, injunctions, specific performance, or declarations. Adversarial nature. The suit involves a plaintiff and defendant, with the court adjudicating based on evidence and law. Illustration. A dispute over the ownership of immovable property between two individuals is a suit of a civil nature, as it involves a private right, property ownership, and seeks a civil remedy, declaration of title. Conversely, a criminal proceeding for theft under the Indian Penal Code is not a civil suit. Exceptions to jurisdiction. Section 9 excludes suits that are expressly or impliedly barred. Expressly barred statutes like the Industrial Disputes Act, 1947, or the WAQF Act, 1995, vest jurisdiction in specialized tribunals, barring civil courts from adjudicating such matters. Impliedly barred, where a statute creates a right and provides a specific remedy through a designated forum, civil courts are impliedly barred. For example, tenancy disputes under state-specific rent control acts are often adjudicated by rent controllers. Illustration. A tenant files a suit in a civil court to challenge an eviction order passed by a rent controller under the Delhi Rent Control Act, 1958. The suit is barred, as the Act expressly vests jurisdiction in the rent controller and appellate authorities. 58. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, prescribes time limits for filing suits of a civil nature. For instance, under Article 58, a suit for a declaration must be filed within 3 years from the date the right to sue accrues. If a suit is filed beyond this period, the court may dismiss it as time-barred, even if it is otherwise within its jurisdiction under Section 9. This interplay ensures that civil courts only entertain timely claims, balancing access to justice with the need to prevent stale litigation. General principles of jurisdiction. Under the CPC, jurisdiction refers to the authority of a court to hear and decide a case. The CPC outlines several principles governing the jurisdiction of civil courts, categorized into subject matter, territorial, pecuniary, and appellate jurisdiction. These principles ensure that suits are adjudicated by the appropriate court, based on the nature of the dispute, the location of the parties or subject matter, and the value of the claim. 1. Subject matter jurisdiction. Subject matter jurisdiction determines whether a court has the authority to hear a particular type of dispute. Under Section 9, civil courts have general jurisdiction over suits of a civil nature unless barred. However, specific statutes may confer exclusive jurisdiction on specialized forums. Illustration. A suit for recovery of damages for breach of contract falls within the subject matter jurisdiction of a civil court. However, A dispute over patent infringement is adjudicated by the Intellectual Property Appellate Board under the Patents Act, 1970, barring civil court jurisdiction. 2. Territorial jurisdiction. Territorial jurisdiction, governed by sections 15 to 20 of the CPC, determines the geographical area within which a court can exercise its authority. Key provisions include, Section 16, suits for immovable property must be filed in the court within whose jurisdiction the property is situated. Section 17, if the property is situated in multiple jurisdictions, the suit may be filed in any court within whose jurisdiction a portion of the property lies. Section 20, for other suits, jurisdiction lies where the defendant resides, carries on business, or where the cause of action wholly or partly arises. Illustration, a plaintiff in Delhi seeks to recover a debt from a defendant residing in Mumbai, where the contract was executed. Under Section 20, c, the suit can be filed in Mumbai, as the cause of action, contract execution, arose there. 59.3. Pecuniary jurisdiction. Pecuniary jurisdiction, under Section 15, requires suits to be filed in the court of the lowest grade competent to try them, based on the value of the suit. Each state establishes pecuniary limits for courts, e.g., district courts, subordinate courts. Illustration, a suit for recovery of Rs 5 lakhs is filed in a state where the subordinate court has jurisdiction up to Rs 10 lakhs. The suit must be filed in the subordinate court, not the district court, to comply with Section 15. For appellate jurisdiction. Appellate jurisdiction is governed by Sections 96 to 112 and Orders 41 to 45 of the CPC. Appeals from original decrees lie to higher courts, e.g., district court, or high court, subject to the Limitation Act's time limits, e.g., Article 116 prescribes 90 days for appeals to a high court. Illustration, a plaintiff loses a suit in a subordinate court and files an appeal in the district court within 30 days, as prescribed by Article 117 of the Limitation Act. The district court has appellate jurisdiction to hear the appeal. 5. Inherent jurisdiction. Under Section 151, courts have inherent jurisdiction to pass orders necessary for the ends of justice or to prevent abuse of the process of the court. This jurisdiction is exercised sparingly and only when no other remedy is available. Illustration, a party seeks to amend a plaint after the limitation period due to a clerical error. The court may invoke Section 151 to allow the amendment, provided it does not prejudice the other party. Judicial interpretations and leading case laws. The judiciary has significantly shaped the interpretation of suits of a civil nature and jurisdictional principles through landmark decisions. Below are analyses of key cases. Anathula Sudhakar vp Bucci Reddy, 2008, in Anathula Sudhakar vp Bucci Reddy, 2008, 4 SCC 594, the Supreme Court clarified the scope of Section 9. The case involved a suit for an injunction to restrain interference with possession of property. The defendant argued that the suit was barred due to a specific statute. The court held that a suit for an injunction is a civil nature suit unless expressly or impliedly barred. The court laid down guidelines to determine when a suit is barred, if the statute creates a right and provides a specific remedy through a designated forum, civil courts are impliedly barred. If the statute is silent on remedies, civil courts retain jurisdiction. 60. Analysis. This case underscores the broad scope of Section 9, emphasizing that civil courts are courts of general jurisdiction unless ousted by specific legislation. It guides practitioners in assessing whether a dispute falls within civil court jurisdiction. Salem Advocate Bar Association v. Union of India, 2005. In Salem Advocate Bar Association v. Union of India, 2005, 6 SCC 344, the Supreme Court addressed the interplay between the CPC and the Limitation Act in the context of jurisdictional issues. The case arose from amendments to the CPC introducing time-bound procedures, e.g., Order 8, Rule 1 for filing written statements within 30 days. The court held that while procedural timelines are mandatory, Courts must exercise discretion under Section 151 or the Limitation Act, e.g., Section 5 for condonation of delay, to prevent injustice. Analysis: this case highlights the role of the Limitation Act in ensuring that procedural delays do not undermine jurisdiction. It emphasizes the court's power to balance strict timelines with equitable considerations. Safedevi v. Persona, 2010, in Safedevi v. Persona, 2010, 5 SCC 622, the Supreme Court examined territorial jurisdiction under Section 20. The plaintiff filed a suit for specific performance in Chennai, where the contract was executed, although the defendant resided in Bangalore. The court held that the suit was maintainable in Chennai, as the cause of action arose there. The court clarified that Section 20(c) allows flexibility in choosing the forum where the cause of action arises, ensuring access to justice. Analysis: this case illustrates the practical application of territorial jurisdiction, particularly in contract disputes, and underscores the importance of identifying where the cause of action arises. Practical illustrations to further elucidate the concepts: consider the following scenarios. 1 scenario under Section 9, a plaintiff files a suit for partition of ancestral property in a civil court. The defendant argues that the matter falls under the jurisdiction of a revenue court under a State Land Reform Act. The civil court must determine whether the act expressly or impliedly bars its jurisdiction. If the act provides a specific remedy through a revenue court, the suit is barred. Otherwise, the civil court retains jurisdiction. 2 scenario under Section 16, a suit for recovery of immovable property located in Kolkata is filed in a Delhi court. The court dismisses the suit for lack of territorial jurisdiction, as Section 16 mandates that such suits be filed where the property is situated, Kolkata. 3 scenario under Section 15, a plaintiff files a suit for Rs 15 lakhs in a high court with original jurisdiction up to Rs 20 lakhs. The suit is returned, as Section 15 requires it to be filed in the subordinate court with competent pecuniary jurisdiction. 61 Critical analysis: the concept of suits of a civil nature under Section 9 reflects the CPC's commitment to ensuring access to justice for disputes involving private rights. However, the exceptions for expressly or impliedly barred suits create complexities, as litigants must navigate a web of statutes to determine the appropriate forum. The principles of jurisdiction: subject matter, territorial, pecuniary, and appellate provide a structured framework but require careful application to avoid jurisdictional errors. The judiciary's role in interpreting these provisions, as seen in cases like Anathula Sudhakar, ensures clarity but also highlights the need for legislative precision in defining exclusions. The interplay with the Limitation Act, 1963, adds another layer of complexity. For instance, a suit within a civil court's jurisdiction may be dismissed if filed beyond the limitation period, e.g., 3 years for recovery of debts under Article 55. The court's inherent powers under Section 151 and provisions like Section 5 of the Limitation Act provide flexibility, but their discretionary nature can lead to inconsistent outcomes. 62 Question 14. What is constructive res judicata? Explain essentials of residential judicata. Also discuss its nature and scope. What is constructive res judicata? Explain essentials of residential judicata. Also discuss its nature and scope. Understanding residential judicata. Res judicata is a legal principle that prohibits the re-adjudication of a matter that has been finally decided by a competent court between the same parties. Codified under Section 11 of the CPC, it applies to suits and ensures that a final judgment is conclusive not only on the issues actually decided but also on those that could have been raised. The doctrine is based on 3 maxims: nemo debet bis vexari pro una et idem causa, no one should be vexed twice for the same cause. Interest republici ut sit finus litium, it is in the interest of the state that there be an end to litigation. Residential judicata pro veritate accipitur, a matter adjudged is taken as truth. Section 11 of the CPC states that no court shall try any suit or issue in which the matter directly and substantially in issue has been adjudicated in a former suit between the same parties, under the same title, in a competent court. The doctrine applies to civil suits, appeals, and certain other proceedings, ensuring that judicial decisions are final and binding. Constructive residential judicata. Constructive res judicata embodied Indiana explanation 4 of Section 11, extends the doctrine to issues that were not raised but could and should have been raised in the earlier suit. It prevents parties from splitting their claims or introducing new grounds in subsequent litigation that were available during the prior proceedings. Explanation 4 states, any matter which might and ought to have been made ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in issue in such suit. This principle ensures that all relevant claims and defenses are consolidated in a single suit, promoting judicial efficiency and preventing abuse of the legal process. For example, if a plaintiff sues for possession of property but fails to claim damages for trespass, which arose from the same transaction, constructive residential judicata bars a subsequent suit for damages. Essentials of residential judicata. For res judicata to apply, certain conditions must be satisfied, as outlined in Section 11 of the CPC. These essentials, as elucidated in judicial pronouncements like Citiat Hyangosal v. D. Origin Debi, Air 1960 SC 941, are, 63-1. Same parties. The parties in the former and subsequent suits must be the same or their representatives in interest. For instance, in Judicial v. State of UP, Air 1961 SC 1457, the Supreme Court held that residential judicata applies to parties and their privies. To same matter directly and substantially in issue, the issue in the subsequent suit must have been directly and substantially in issue in the former suit. This means the issue must be essential to the decision, not merely collateral or incidental. 3. Same title. The parties must litigate under the same title or capacity in both suits. For example, a person suing as an individual in one suit cannot invoke residential judicata if sued American Samoa a trustee in another. 4. Competent court. The former suit must have been decided by a court with jurisdiction to adjudicate the matter. In Raj Lakshmi Dasi v. Bonamali Sen, Air 1953 SC 33, the Supreme Court clarified that a court lacking jurisdiction cannot render a binding decision for residential judicata purposes. 5. Final decision. The matter must have been heard and finally decided in the former suit. A decision that is not final, such as an interlocutory order, does not attract residential judicata. 6. Constructive residential judicata. Explanation for any matter that could and should have been raised in the former suit is deemed to have been decided, preventing its relitigation. These essentials ensure that residential judicata operates American Samoa a shield against repetitive litigation, protecting the integrity of judicial decisions. Landmark case, Citiat Hyangosal v. D. Origin Debi. In Citiat Hyangosal v. D. Origin Debi, Air 1960 SC 941, the Supreme Court elucidated the principles of residential judicata and constructive res judicata. The case involved a landlord-tenant dispute where the tenant challenged the landlord's title in a second suit after failing to raise it in an earlier eviction proceeding. The court held that the tenant was barred by constructive residential judicata under explanation for American Samoa. The issue of title could and should have been raised in the first suit. The court emphasized that residential judicata is not merely a technical rule but a principle of public policy that promotes finality and prevents harassment. This case underscores the importance of consolidating all relevant claims in a single suit to avoid piecemeal litigation. Nature of residential judicata. The nature of residential judicata is multifaceted, serving both procedural and substantive purposes. 1. Procedural safeguard. Residential judicata is a procedural rule under the CPC that regulates the conduct of litigation. It ensures that courts do not waste resources on matters already adjudicated, as seen in Workman of Cochin Port Trust v. Board of Trustees, Air 1978 SC 1283, where the Supreme Court applied residential judicata to bar relitigation of labor disputes. 64-2. Public policy principle, the doctrine reflects the public interest in ending litigation and upholding the finality of judgments. It prevents parties from re-agitating settled matters, thereby maintaining judicial authority. 3. Substantive effect, while primarily procedural, residential judicata has a substantive impact by conclusively determining rights and obligations. A decision barred by residential judicata cannot be challenged except through appeal or review. 4. Universal application, residential judicata applies not only to civil suits but also to writ petitions, arbitration proceedings, and certain administrative matters, as clarified in der LL.B. State of UP, Air 1961 SC 1457. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, complements residential judicata by imposing time limits on legal actions, ensuring that claims are pursued diligently. For instance, Article 59 prescribes a 3-year limitation period for suits to set aside an instrument. If a party fails to raise a claim within this period and attempts to relitigate it in a subsequent suit, residential judicata may bar the claim if it was or could have been raised earlier. In State of Punjab v. Gurdeep Singh, Air 1991 SC 2219, the Supreme Court held that a time-barred claim cannot be entertained unless condoned under Section 5 of the Limitation Act, reinforcing the finality principle akin to residential judicata. Scope of residential judicata. The scope of residential judicata is broad but subject to certain limitations. 1. Application to suits and issues. Residential judicata applies to entire suits and specific issues within suits. It covers both questions of fact and law decided in the former suit. 2. Constructive residential judicata. Explanation 4 extends the doctrine to matters that could have been raised, preventing parties from splitting claims. For example, in Alka Gupta v. Narendra Kumar Gupta, 2010, 10 SCC 141, the Supreme Court applied constructive residential judicata to bar a subsequent claim for maintenance that could have been raised in a prior divorce proceeding. 3. Exceptions. Residential judicata does not apply Indiana cases of fraud, collusion, or lack of jurisdiction in the former suit. Additionally, it does not bar subsequent suits based on a new cause of action, as seen in Shiv Shankar Gurgar v. Dilip, 2014, 2 SCC 465. For writ petitions, the Supreme Court in der LL.B. State of UP extended residential judicata to writ petitions under Article 32, ensuring that constitutional remedies are not abused through repetitive litigation. 5. Public interest litigation. PIL residential judicata applies cautiously to PIL's American Samoa. Public interest may require re-examination of issues in exceptional cases. 65. Landmark case, Workman of Cochin Port Trust v. Board of Trustees. In Workman of Cochin Port Trust v. Board of Trustees, Air 1978 SC 1283, the Supreme Court applied residential judicata to a labor dispute where workmen raised new grounds in a subsequent proceeding that could have been raised earlier. The court held that constructive residential judicata barred the new claims, emphasizing that parties must exhaust all grounds in the initial litigation to avoid multiplicity of proceedings. This case illustrates the doctrine's role in promoting judicial economy and preventing abuse of process, particularly in disputes involving multiple claims arising from the same transaction. Practical illustrations to clarify the application of residential judicata and constructive res judicata. Consider the following scenarios. 1. Property dispute. A sues B for possession of property but does not claim mean profits. After winning possession, A files a second suit for mean profits. Under Explanation 4, constructive residential judicata bars the second suit. American Samoa mean profits could have been claimed in the first suit. 2. Contract breach. C sues D for breach of contract under Section 9 of the CPC but fails to raise a claim for specific performance. A subsequent suit for specific performance is barred by constructive residential judicata as it arises from the same cause of action. 3. Limitation and residential judicata. E files a suit against F for recovery of debt after the 3-year limitation period, Article 55, Limitation Act. Even if the suit is dismissed as time-barred, residential judicata may apply to prevent E from relitigating the same claim under a different guise. These examples demonstrate how residential judicata and the Limitation Act work together to ensure finality and efficiency in civil litigation. 66 Question 15. Discuss law and procedure relating to suits by or against government. Whether notice required under Section 80 can be waived by the government. Discuss law and procedure relating to suits by or against government. Whether notice required under Section 80 can be waived by the government. Legal framework for suits by or against the government. The CPC provides a specialized procedure for suits involving the government, recognizing its distinct legal status. The key provisions are, Section 79, Suits by or against government. Section 79 specifies the manner in which suits by or against the government should be instituted. In suits against the central government, the Union of India is the named party, while in suits against a state government, the state is the defendant. For example, a suit challenging a tax assessment by the Central Board of Direct Taxes would name the Union of India as the defendant. Section 80, Notice Requirement. Section 80, 1. Mandates that no suit shall be instituted against the government or a public officer in respect of any act purporting to be done in their official capacity until 2 months have elapsed after the service of a notice in writing. The notice must state the cause of action, the name, description, and place of residence of the plaintiff, the relief claimed. The notice must be delivered to the appropriate authority, such as the Secretary to the Government for the Central Government or the Chief Secretary for the State Government. Section 80, 2. The purpose of this provision is to afford the government an opportunity to examine the claim and resolve it amicably, thereby avoiding unnecessary litigation. Section 80, 2. Allows the court to grant leave to institute a suit without serving the notice in cases of urgent or immediate relief, provided the court is satisfied that no substantial injustice will result to the government. For instance, in a case where a plaintiff seeks an urgent injunction to prevent the demolition of their property by a government authority, the court may waive the notice requirement under Section 80, 2. Sections 81 and 82, Procedural Safeguards. Section 81 exempts the government from arrest or personal appearance in court, reflecting the principle that the state cannot be subjected to personal liability. Section 82 provides that decrees against the government shall not be executed until 3 months from the date of the decree, allowing the government time to comply voluntarily or appeal. 67 Order 27, Procedure for Suits Involving Government. Order 27 lays down the procedural rules for suits by or against the government, including the appointment of a government pleader to represent the government. Order 27, Rule 1. The duty of the court to issue notices to the government in certain cases. Order 27, Rule 5. The government's right to seek adjournments for obtaining instructions. Order 27, Rule 8. For example, in a suit filed by the government for recovery of dues, the government pleader represents the state, ensuring that procedural formalities are adhered to. Procedure for suits by or against the government. The procedure for suits involving the government follows the general rules of the CPC, subject to the modifications outlined in Section 7982 and Order 27. The key steps are, suits against the government. 1. Serving notice. Under Section 80, the plaintiff must serve a notice to the appropriate government authority, specifying the cause of action and relief sought. The suit can only be filed after 2 months, unless leave is granted under Section 80, 2. 2. Filing the plaint must name the Union of India or the state as the defendant, as per Section 79. It must comply with the requirements of Order 7, CPC, including payment of court fees. 3. Summons and written statement. The court issues summons to the government, which is represented by the government pleader. The government files a written statement under Order 8, CPC, outlining its defense. 4. Trial and adjudication. The suit proceeds to trial, with the government enjoying certain procedural privileges, such as adjournments for obtaining instructions. Order 27, Rule 8. 5. Decree and execution. If a decree is passed against the government, execution is subject to a 3-month moratorium under Section 82, CPC. For example, in a suit for compensation due to wrongful termination by a government department, the plaintiff must first serve a notice under Section 80 to the department's secretary, wait 2 months, and then file the suit naming the Union of India as the defendant. Suits by the government. When the government initiates a suit, it follows the standard procedure under the CPC, with the government pleader acting on behalf of the state. For instance, in a suit for recovery of unpaid taxes, the Union of India files the plaint, and the defendant is served summons under Order 5, CPC. The government is not required to serve a notice under Section 80 when suing, as the provision applies only to suits against the government. 68 Waiver of notice under Section 80. The requirement of notice under Section 80 is mandatory, and non-compliance generally renders a suit defective. However, the question of whether the government can waive this notice is a nuanced one, addressed by judicial interpretations and statutory provisions. General Rule: mandatory nature of Section 80. The Supreme Court has consistently held that the notice under Section 80 is a condition precedent to instituting a suit against the government. In State of Punjab v. Gita Iron Brass Works Limited, AIR 1978 SC 1608, the court emphasized that the object of Section 80 is to enable the government to investigate the claim and avoid litigation if possible. Failure to serve a valid notice results in the dismissal of the suit, as seen in Government of UP v. J.B. Sharma, AIR 1982 All 234, where a suit was dismissed for non-compliance with Section 80. Waiver by the government. The courts have recognized that the government can waive the notice requirement under Section 80, as the provision is intended for its benefit. The waiver can be express or implied, depending on the government's conduct in the proceedings. Key judicial pronouncements include: express waiver: if the government explicitly agrees to forego the notice requirement, the court may proceed with the suit. For example, in Bagchan Degajasa v. Secretary of State, AIR 1927 PC 176, the Privy Council held that the government could waive the notice if it chose not to raise the objection of non-compliance with Section 80. Implied waiver: the government's conduct, such as filing a written statement without objecting to the lack of notice, may constitute an implied waiver. Indian Singh Sabha Singh v. Union of India, AIR 1958 SC 274, the Supreme Court observed that if the government participates in the suit without raising the issue of notice at the earliest opportunity, it may be deemed to have waived the requirement. However, the waiver must be clear and unequivocal. In State of AP v. Pioneer Builders, AIR 2007 SC 113, the Supreme Court clarified that the government's failure to raise the objection in the written statement does not automatically waive the notice, unless its conduct demonstrates a clear intent to proceed with the suit. Section 80, 2 Judicial discretion. Section 80, 2, allows the court to dispense with the notice in urgent cases, but this is distinct from waiver by the government. The plaintiff must apply for leave, and the urgency must be substantiated. For instance, in State of Kerala v. General Manager, Southern Railway, AIR 1976 SC 2538, the court granted leave under Section 80, 2, to file a suit without notice to prevent irreparable harm to the plaintiff's property. 69 Practical illustration: consider a case where a plaintiff files a suit against the state government for wrongful demolition of their shop without serving a Section 80 notice. If the government files a written statement defending the suit on merits without objecting to the absence of notice, the court may infer an implied waiver, as seen in Indian Singh Sabha Singh v. Union of India, AIR 1958 SC 274. Conversely, if the government raises the objection at the first hearing, the suit is liable to be dismissed unless leave is granted under Section 80, 2. Relevance of the Limitation Act, 1963. The Limitation Act, 1963, is intricately linked to suits by or against the government, particularly in prescribing time limits for filing suits, appeals, and executing decrees. Key provisions include: Article 112, A suit by the government for recovery of money or property has a limitation period of 30 years, as opposed to the general 3-year period under Article 6 for private individuals. For example, in NAB Ratanmal v State of Rajasthan, Air 1961 SC 1704, the Supreme Court upheld the government's right to recover arrears of rent within 30 years under Article 112. Article 136, the execution of a decree, including against the government, must be applied for within 12 years from the date the decree becomes enforceable. In Union of India v West Coast Paper Mills Limited, Air 2004 SC 1596, the court emphasized that delays in execution beyond this period require condonation under Section 5 of the Limitation Act. Section 80, CPC and limitation, the 2-month notice period under Section 80 does not extend a limitation period for filing a suit. In B.L. Gupta v. M.C. Gupta, Air 1979 SC 1656, the court held that the plaintiff must account for the notice period within the limitation period prescribed by the Limitation Act. For instance, if a plaintiff has a 3-year limitation period to file a suit for compensation against the government, Article 72, Limitation Act, they must serve the Section 80 notice well in advance to file the suit within 3 years from the accrual of the cause of action. Leading case law. The following cases provide authoritative guidance on suits by or against the government and the notice requirement under Section 80, Bagchand Dagajasabi Secretary of State, Air 1927 PC 176, this landmark Privy Council decision established that the notice under Section 80 is mandatory but can be waived by the government. The plaintiff filed a suit against the government without serving a notice, and the government did not object to the defect. The court held that the government's participation in the suit constituted a waiver, allowing the suit to proceed. This case is significant for its recognition of the government's discretion to forego procedural protections. 70 State of Punjab v Geeta Iron Brass Works Limited, Air 1978 SC 1608, in this case, the Supreme Court reiterated the mandatory nature of Section 80, dismissing a suit for non-compliance with the notice requirement. The court emphasized that the provision serves a public purpose by enabling the government to settle claims without litigation. The case underscores the importance of adhering to Section 80, unless waived by the government or dispensed with under Section 80. 2. Dhyan Singh Sabha Singh v Union of India, Air 1958 SC 274, this case clarified the concept of implied waiver. The government defended a suit on merits without objecting to the absence of a Section 80 notice. The Supreme Court held that the government's conduct amounted to a waiver, allowing the suit to continue. The case is a valuable precedent for understanding how courts interpret the government's actions in litigation. Practical illustrations. To illustrate the application of these principles, consider the following scenarios. 1. Suit against government for breach of contract. A contractor files a suit against the state government for non-payment of dues under a construction contract. The contractor serves a notice under Section 80 to the Chief Secretary, waits 2 months, and files the suit naming the state as the defendant. The suit is filed within 3 years of the breach, Article 55, Limitation Act. The government pleader represents the state, and the suit proceeds under Order 27. If the court passes a decree, execution is deferred for 3 months under Section 82, CPC. 2. Urgent suit without notice. A plaintiff seeks an urgent injunction to prevent a government agency from acquiring their land without due process. The plaintiff applies for leave under Section 80, 2, citing irreparable harm. The court grants leave, and the suit proceeds without a notice, as in State of Kerala v General Manager, Southern Railway, Air 1976 SC 2538. 3. Suit by government for recovery of property. The Union of India files a suit to recover encroached government land from a private individual. The suit is filed within 30 years of the encroachment, Article 112, Limitation Act, and the government pleader represents the plaintiff. No notice under Section 80 is required, and the suit proceeds as per the standard procedure under the CPC. 71 Question 16, discuss powers of the court to enforce execution. Explain the law relating to arrest and detention as a mode of execution of decree. Discuss powers of the court to enforce execution. Explain the law relating to arrest and detention as a mode of execution of decree. Powers of the court to enforce execution. The CPC vests courts with extensive powers to enforce decrees, ensuring that the rights adjudicated in favor of the decree holder are realized. Execution is the process by which a court enforces its decree or order, compelling the judgment debtor to comply. The key provisions governing execution are: General Framework of Execution Section 36, provisions relating to the execution of decrees also apply to orders. Section 38, a decree may be executed by the court that passed it or by a court to which it is transferred for execution. Section 51, enumerates the modes of execution, including delivery of property, specific movable or immovable property, attachment and sale of property, arrest and detention in civil prison, appointment of a receiver, any other mode as the court deems fit. Order 21 provides detailed procedural rules for execution, covering applications, modes, and objections. Powers of the executing court. The executing court has the following powers under the CPC. 1. Determine execution mode. Under Section 51, the court has discretion to choose the appropriate mode of execution based on the nature of the decree, e.g., monetary, specific performance, injunction. 2. Attachment and sale. Order 21, Rules 46 to 54 govern the attachment and sale of movable and immovable property to satisfy monetary decrees. 3. Arrest and detention. Section 51, c, and Order 21, Rules 37 to 40 allow the court to order arrest and detention of the judgment debtor for non-payment of a monetary decree, subject to conditions. 72.4. Appointment of receiver. Section 51, d, and Order 40 permit the court to appoint a receiver to manage the judgment debtor's property. 5. Adjudicate objections. Order 21, Rule 58 empowers the court to decide objections to attachment or execution by third parties claiming an interest in the property. 6. Issue precepts. Section 46 allows the court to issue precepts to another court to attach the judgment debtor's property. 7. Stay execution. Order 21, Rule 26 permits the court to stay execution if sufficient cause is shown, such as an appeal pending before a higher court. Illustration: a decree holder obtains a monetary decree for Rs 10 lakhs. The judgment debtor fails to pay. The court may, under Section 51, order attachment of the debtor's property, Order 21, Rule 54, or, if the debtor has means but refuses to pay, order arrest and detention, Section 51, c. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, governs the time limits for initiating execution proceedings. Under Article 136, an application for execution of a decree must be filed within 12 years from the date the decree becomes enforceable. However, Section 15 of the Limitation Act excludes certain periods, e.g., time during an injunction or stay, from computation, ensuring that procedural delays do not prejudice the decree holder. Illustration: a decree is passed on January 1, 2013, but an injunction stays its execution from January 1, 2014 to January 1, 2015. The one-year period is excluded under Section 15, extending the limitation period to January 1, 2026. Arrest and detention as a mode of execution. Arrest and detention in civil prison is a coercive measure to enforce monetary decrees when the judgment debtor has the means to pay but refuses or neglects to do so. This mode is governed by Section 51, c, Section 55, and Order 21, Rules 37 to 40. It is a remedy of last resort, used only when other modes, e.g., attachment and sale, are ineffective or inappropriate. Legal framework for arrest and detention. Section 51, C. Empowers the court to order arrest and detention in execution of a decree for payment of money. Section 55 outlines the procedure for arrest and detention, including release conditions, e.g., payment of the decretal amount or furnishing security. Order 21, Rule 37, for monetary decrees, the court may issue a notice to the judgment debtor to show cause why they should not be arrested, unless the decree holder provides evidence that the debtor has means to pay. 73 Order 21, Rule 40, if the debtor fails to show cause or pay, the court may order detention in civil prison after a hearing. The maximum period of detention is 6 months for decrees exceeding Rs 5,000, Section 58, 1a. 6 weeks for decrees between Rs 2,000 and Rs 5,000, Section 58, 1b. No detention for decrees below Rs 2,000, Section 58, 2. Proviso to Section 51, before ordering arrest, the court must be satisfied that the judgment debtor, 1 has, or had, the means to pay the decretal amount but refuses or neglects to pay. 2 has disposed of property fraudulently to avoid payment. 3 is about to abscond or leave the court's jurisdiction to evade payment. Procedural safeguards to prevent misuse of arrest and detention, the CPC incorporates safeguards, notice to show cause, under Order 21, Rule 37, the court issues a notice to the judgment debtor to explain why they should not be detained, ensuring due process. Hearing, Order 21, Rule 40 mandates a hearing to assess the debtor's financial capacity and intent. Exemptions, Section 56 prohibits the arrest of women and certain other persons, e.g., minors, legal representatives of deceased debtors, in execution of monetary decrees. Release provisions, Section 55, 4, allows release if the debtor pays the decretal amount, furnishes security, or if the decree is satisfied. Illustration, a decree holder obtains a decree for Rs 8 lakhs. The judgment debtor, a businessman, owns assets worth Rs 15 lakhs but refuses to pay. The court issues a notice under Order 21, Rule 37. At the hearing, Rule 40, the debtor fails to show financial inability. The court orders detention for up to 6 months, Section 58, 1a. If the debtor is a woman, Section 56 prohibits arrest. Limitations and exceptions. Arrest and detention are subject to, Section 58, to no detention for decrees below Rs 2000. Section 56, prohibition on arresting women or certain protected persons. Limitation Act, 1963, execution applications must be filed within 12 years, Article 136, subject to exclusions under Section 15. 74 Judicial interpretations and leading case laws. The judiciary has clarified the scope and application of execution powers, particularly arrest and detention, through landmark decisions. Jolly George Varghese v. Bank of Cochin, 1980, in Jolly George Varghese v. Bank of Cochin, Air 1980 SC 470, the Supreme Court addressed the constitutional validity of arrest and detention under Section 51, c. The judgment debtor, unable to pay a monetary decree due to financial distress, was ordered to be detained. The court held that arrest and detention should not be ordered mechanically. The court must satisfy itself that the debtor has the means to pay but is willfully refusing, aligning with the proviso to Section 51. The court also emphasized that detention for inability to pay violates Article 21 of the Constitution, right to personal liberty, and Article 11 of the International Covenant on Civil and Political Rights, which prohibits imprisonment for mere inability to fulfill a contractual obligation. Analysis: this case underscores the humane approach to arrest and detention, ensuring that it is not used to punish poverty. It mandates a rigorous inquiry into the debtor's financial capacity, reinforcing the safeguards in Order 21, Rule 40. Satya Narain v. High Court of Allahabad, 2004, in Satya Narain v. High Court of Allahabad, 2004, 2 SCC 225, the Supreme Court clarified the scope of Section 51 and Order 21. The case involved a decree holder seeking execution through attachment and arrest. The court held that the executing court has discretion to choose the mode of execution but must act judicially, considering the facts and circumstances. For arrest, the court must record reasons why other modes, e.g., attachment, are ineffective. Analysis: this case highlights the discretionary yet reasoned approach required in execution proceedings, ensuring that arrest is not a default remedy but a carefully considered option. K. Venkateshwarlu v. Venkatswara Rao, 1971, in K. Venkateshwarlu v. Venkatswara Rao, Air 1971 SC 220, the Supreme Court examined the procedural requirements for arrest under Order 21, Rule 37. The court held that the issuance of a show cause notice is mandatory, and failure to provide the judgment debtor an opportunity to be heard vitiates the arrest order. The court emphasized the importance of due process in coercive measures like detention. Analysis: this case reinforces the procedural safeguards in Order 21, ensuring that arrest and detention comply with principles of natural justice. Practical illustrations to illustrate the application of these provisions: consider the following scenarios. One scenario under Section 51, a decree holder obtains a decree for Rs 12 lakhs. The judgment debtor owns a factory worth Rs 20 lakhs but refuses to pay. The court attaches the 75 factory under Order 21, Rule 54. When the debtor still does not comply, the court issues a notice under Order 21, Rule 37 and, after a hearing, orders detention for 3 months, as the debtor has the means to pay, Section 51, c. 2 scenario under Section 56, a decree holder seeks to execute a decree of Rs 6 lakhs against a female judgment debtor. The court refuses to order arrest, citing Section 56, and proceeds with attachment of the debtor's property instead. 3 scenario under Limitation Act, a decree is passed on January 1, 2010, but an injunction stays execution from January 1, 2011 to January 1, 2012. The decree holder files for execution on January 1, 2023. The 1-year stay is excluded under Section 15, making the application within the 12-year limit, Article 136. Critical analysis: the CPC's execution framework empowers courts to enforce decrees effectively, ensuring that judgments are not mere paper decrees. The availability of multiple modes under Section 51 provides flexibility, allowing courts to tailor remedies to the case's circumstances. However, arrest and detention, as a coercive measure, raise ethical and constitutional concerns, as highlighted in Jolly George Varghese. The requirement to prove the debtor's ability and willful refusal to pay ensures that detention is not used oppressively, but it places a burden on decree holders to provide evidence, which can be challenging in cases of concealed assets. The interplay with the Limitation Act, 1963, ensures timely execution but also protects decree holders from procedural delays through exclusions under Section 15. However, the 1-2-year limitation period may be overly generous in some cases, potentially delaying justice for judgment debtors. The procedural safeguards in Order 21, such as notices and hearings, uphold natural justice but can prolong execution proceedings, particularly in contentious cases. 76 Question 17, explain substantial question of law. Also discuss the powers of the appellate court. Explain substantial question of law. Also discuss the powers of the appellate court. Understanding substantial question of law. A substantial question of law is a pivotal concept in the context of second appeals under Section 100 of the CPC. This section stipulates that a second appeal to the High Court lies only if the case involves a substantial question of law. Unlike questions of fact, which are generally settled by trial courts and first appellate courts, a substantial question of law pertains to legal principles, interpretations, or applications that significantly impact the outcome of the case. The term substantial question of law is not explicitly defined in the CPC, but judicial pronouncements have clarified its meaning. in LL.B Meta and Sons Limited v Century Spinning and Manufacturing Co. Limited, Air 1962 SC 1314, the Supreme Court held that a substantial question of law arises when there is a debatable legal issue of general importance or when the lower court's decision is based on an erroneous application of law. The court emphasized that such a question must be significant, not trivial, and must have a material bearing on the rights of the parties. Essentials of a substantial question of law: to qualify as a substantial question of law, certain conditions must be met, as elucidated in Santosh Hazare v. Purushottam Tiwari, 2001, 3 SCC 179, 1. Legal issue of significance: the question must involve a legal principle or interpretation that is debatable or unsettled. For instance, misinterpretation of a statute or contract clause may constitute a substantial question of law. 2. Material impact: the question must materially affect the outcome of the case. A mere error in law that does not influence the decision is not substantial. 3. General importance: the question should have broader implications, either for the parties or for similar cases, rather than being confined to the specific facts of the case. 4. Erroneous application or non-application of law: a substantial question arises if the lower court applies a wrong legal principle, fails to apply the correct law, or misinterprets evidence in a manner that affects legal conclusions. 5. Not a question of fact: the High Court cannot re-examine findings of fact in a second appeal unless they are perverse or based on no evidence. In Ramalapudi Subbarao v. Nuni Viraju, Air 1951 SC 376, the Supreme Court clarified that reappreciation of evidence is beyond the scope of Section 100. Landmark case: LL.B Meta and Sons Limited v Century Spinning. In LL.B Meta and Sons Limited v Century Spinning and Manufacturing Co. Limited, Air 1962 SC 1314, the Supreme Court provided a seminal interpretation of a substantial question of law. 77. The case involved a dispute over the interpretation of a managing agency agreement. The High Court, in a second appeal, reversed the lower court's findings on the grounds of erroneous legal interpretation. The Supreme Court upheld the High Court's decision, stating that a substantial question of law arises when there is a misconstruction of a document or statute that materially affects the parties' rights. This case established that a substantial question of law is not limited to novel legal issues but includes errors in applying settled law to the facts of the case. It underscored the High Court's role in correcting legal errors while respecting the finality of factual findings. Powers of the Appellate Court: the powers of appellate courts under the CPC are extensive, designed to ensure justice by reviewing lower court decisions for errors in law, fact, or procedure. These powers are primarily governed by Sections 96-108 and Order XLI of the CPC, which outline the scope and procedure for appeals. Appellate courts, including district courts, first appeals, and high courts, second appeals, exercise their powers to correct errors, uphold justice, and ensure compliance with procedural and substantive law. First appeals, Sections 96-99 and Order XLI. Section 96 of the CPC provides for a first appeal from a decree passed by a court exercising original jurisdiction. The appellate court in a first appeal has broad powers to review both facts and law, as it is an extension of the original suit. The key powers include: 1. Reappreciation of evidence. Under Order XLI, Rule 24, the appellate court can re-examine evidence to determine if the trial court's findings are supported by the record. In Maiden-Lal v. Gopi, 1980, 4 SCC 255, the Supreme Court held that the first appellate court is the final court of fact and must thoroughly analyze evidence. 2. Reversing or modifying decrees. Section 96 allows the appellate court to reverse, modify, or affirm the trial court's decree. This includes setting aside findings that are perverse or unsupported by evidence. 3. Remanding the case. Under Order XLI, Rule 23, the appellate court can remand the case to the trial court for fresh consideration if the lower court failed to decide a material issue or if further evidence is required. 4. Taking additional evidence. Order XLI, Rule 27 permits the appellate court to admit additional evidence if it was not available during the trial or if its exclusion caused injustice. However, this power is exercised sparingly, as seen in K. Venkataramaya v. Sitha, 1983, 4 SCC 294. 5. Framing issues. Under Order XLI, Rule 25, the appellate court can frame additional issues if the trial court omitted them, ensuring comprehensive adjudication. 78. Second Appeals. Section 100. Second appeals to the High Court under Section 100 are limited to cases involving a substantial question of law. The powers of the High Court are narrower than those in first appeals, focusing on legal errors rather than factual reassessment. Key powers include: 1. Determining substantial questions of law. The High Court must formulate the substantial question of law at the admission stage, Section 100. 4. In Santosh Hazare v. Purushottam Tiwari, 2001, 3 SCC 179, the Supreme Court emphasized that the High Court must clearly state the question before proceeding. 2. Reversing or modifying decrees. If a substantial question of law is established, the High Court can reverse or modify the lower court's decree to correct legal errors. 3. Limited fact review. The High Court cannot reappreciate evidence unless the lower court's findings are perverse or based on no evidence. In Vijaykumar Talwar v. CIT, 2011, 1 SCC 673, the Supreme Court clarified that perverse findings constitute a substantial question of law. 4. Inherent powers. Under Section 151, the High Court can exercise inherent powers to prevent abuse of process or ensure justice, though this is rare in second appeals. Landmark case, Santosh Hazare v. Purushottam Tiwari. In Santosh Hazare v. Purushottam Tiwari, 2001, 3 SCC 179, the Supreme Court clarified the scope of second appeals and the powers of the High Court. The case involved a property dispute where the High Court reappreciated evidence in a second appeal, which was challenged as beyond its jurisdiction. The Supreme Court held that the High Court can interfere only when a substantial question of law arises, such as a misinterpretation of evidence leading to an erroneous legal conclusion. The Court reiterated that the High Court must formulate the substantial question of law and confine its inquiry to that question. This case underscores the limited but critical role of the High Court in correcting legal errors while respecting the finality of factual findings by lower courts. Interplay with the Limitation Act, 1963. The Limitation Act, 1963, plays a crucial role in the appellate process by prescribing time limits for filing appeals. Under Article 116, the limitation period for appeals to the High Court from a decree or order is 90 days, and for appeals to other courts, it is 30 days. Section 5 of the Limitation Act allows condonation of delay if sufficient cause is shown, as seen in Collector, Land Acquisition v. Kaitiji, Air 1987 SC 1353, where the Supreme Court advocated a liberal approach to condonation to ensure access to justice. The Limitation Act ensures that appellate remedies are pursued diligently, complementing the CPC's objective of expeditious justice. For example, if a party fails to file a second appeal within 90 days and cannot justify the delay, the appeal may be dismissed, reinforcing the principle of finality. Practical illustrations to illustrate the concepts of substantial question of law and appellate court powers. Consider the following scenarios: 1. Contract dispute, A sues B for breach of contract, and the trial court dismisses the suit based on an erroneous interpretation of the Indian Contract Act, 1872. The first appellate court upholds the decision. In a second appeal, the High Court finds a substantial question of law in the misinterpretation of the contract clause and reverses the decree, exercising its power under Section 100. 2. Property dispute, C appeals a trial court's decree in a property dispute, claiming the court ignored key evidence. The first appellate court, under Order XLI, Rule 24, re-examines the evidence and sets aside the decree due to perversity, demonstrating its broad fact-finding powers. 3. Limitation issue, D. Files a first appeal 40 days after the trial court's decree, beyond the 30-day limit under Article 116, b. The appellate court condones the delay under Section 5 of the Limitation Act, citing sufficient cause, and proceeds to hear the appeal on merits. These examples demonstrate the practical application of appellate powers and the role of substantial questions of law in ensuring just outcomes. 80. Question 18. When revision petition can be filed. Differentiate between revision and reference. When revision petition can be filed. Differentiate between revision and reference. Legal framework for suits by or against the government. The CPC provides a specialized procedure for suits involving the government, recognizing its distinct legal status. The key provisions are, Section 79, Suits by or against government. Section 79 specifies the manner in which suits by or against the government should be instituted. In suits against the central government, the Union of India is the named party, while in suits against a state government, the state is the defendant. For example, a suit challenging a tax assessment by the Central Board of Direct Taxes would name the Union of India as the defendant. Section 80, Notice Requirement. Section 80, 1. Mandates that no suit shall be instituted against the government or a public officer in respect of any act purporting to be done in their official capacity until 2 months have elapsed after the service of a notice in writing. The notice must state the cause of action, the name, description, and place of residence of the plaintiff, the relief claimed. The notice must be delivered to the appropriate authority, such as the Secretary to the Government for the Central Government or the Chief Secretary for the State Government. Section 80, 2. The purpose of this provision is to afford the government an opportunity to examine the claim and resolve it amicably, thereby avoiding unnecessary litigation. Section 80, 2. Allows the court to grant leave to institute a suit without serving the notice in cases of urgent or immediate relief, provided the court is satisfied that no substantial injustice will result to the government. For instance, in a case where a plaintiff seeks an urgent injunction to prevent the demolition of their property by a government authority, the court may waive the notice requirement under Section 80, 2. Sections 81 and 82, Procedural Safeguards. Section 81 exempts the government from arrest or personal appearance in court, reflecting the principle that the state cannot be subjected to personal liability. Section 82 provides that decrees against the government shall not be executed until 3 months from the date of the decree, allowing the government time to comply voluntarily or appeal. 81. Order 27, Procedure for Suits Involving Government. Order 27 lays down the procedural rules for suits by or against the government, including the appointment of a government pleader to represent the government. Order 27, Rule 1. The duty of the court to issue notices to the government in certain cases. Order 27, Rule 5. The government's right to seek adjournments for obtaining instructions. Order 27, Rule 8. For example, in a suit filed by the government for recovery of dues, the government pleader represents the state, ensuring that procedural formalities are adhered to. Procedure for suits by or against the government. The procedure for suits involving the government follows the general rules of the CPC, subject to the modifications outlined in Section 7982 and Order 27. The key steps are, suits against the government. 1. Serving notice. Under Section 80, the plaintiff must serve a notice to the appropriate government authority, specifying the cause of action and relief sought. The suit can only be filed after 2 months, unless leave is granted under Section 80, 2. 2. Filing the plaint must name the Union of India or the state as the defendant, as per Section 79. It must comply with the requirements of Order 7, CPC, including payment of court fees. 3. Summons and written statement. The court issues summons to the government, which is represented by the government pleader. The government files a written statement under Order 8, CPC, outlining its defense. 4. Trial and adjudication. The suit proceeds to trial, with the government enjoying certain procedural privileges, such as adjournments for obtaining instructions. Order 27, Rule 8. 5. Decree and execution. If a decree is passed against the government, execution is subject to a 3-month moratorium under Section 82, CPC. For example, in a suit for compensation due to wrongful termination by a government department, the plaintiff must first serve a notice under Section 80 to the department's secretary, wait 2 months, and then file the suit naming the Union of India as the defendant. Suits by the government. When the government initiates a suit, it follows the standard procedure under the CPC, with the government pleader acting on behalf of the state. For instance, in a suit for recovery of unpaid taxes, the Union of India files the plaint, and the defendant is served summons under Order 5, CPC. The government is not required to serve a notice under Section 80 when suing, as the provision applies only to suits against the government. 82 Waiver of notice under Section 80. The requirement of notice under Section 80 is mandatory, and non-compliance generally renders a suit defective. However, the question of whether the government can waive this notice is a nuanced one, addressed by judicial interpretations and statutory provisions. General Rule: Mandatory nature of Section 80. The Supreme Court has consistently held that the notice under Section 80 is a condition precedent to instituting a suit against the government. In State of Punjab v. Geeta Iron Brass Works Limited, AIR 1978 SC 1608, the court emphasized that the object of Section 80 is to enable the government to investigate the claim and avoid litigation if possible. Failure to serve a valid notice results in the dismissal of the suit, as seen in Government of UP v. J.B. Sharma, AIR 1982 All 234, where a suit was dismissed for non-compliance with Section 80. Waiver by the government. The courts have recognized that the government can waive the notice requirement under Section 80, as the provision is intended for its benefit. The waiver can be express or implied, depending on the government's conduct in the proceedings. Key judicial pronouncements include: express waiver: if the government explicitly agrees to forego the notice requirement, the court may proceed with the suit. For example, in Bagchan Dagajasabi, Secretary of State, AIR 1927 PC 176, the Privy Council held that the government could waive the notice if it chose not to raise the objection of non-compliance with Section 80. Implied waiver: the government's conduct, such as filing a written statement without objecting to the lack of notice, may constitute an implied waiver. Indian Singh Sabha Singh v. Union of India, AIR 1958 SC 274, the Supreme Court observed that if the government participates in the suit without raising the issue of notice at the earliest opportunity, it may be deemed to have waived the requirement. However, the waiver must be clear and unequivocal. In State of AP v. Pioneer Builders, AIR 2007 SC 113, the Supreme Court clarified that the government's failure to raise the objection in the written statement does not automatically waive the notice, unless its conduct demonstrates a clear intent to proceed with the suit. Section 80, 2 Judicial discretion. Section 80, 2, allows the court to dispense with the notice in urgent cases, but this is distinct from waiver by the government. The plaintiff must apply for leave, and the urgency must be substantiated. For instance, in State of Kerala v. General Manager, Southern Railway, AIR 1976 SC 2538, the court granted leave under Section 80, 2, to file a suit without notice to prevent irreparable harm to the plaintiff's property. 83 Practical illustration: consider a case where a plaintiff files a suit against the state government for wrongful demolition of their shop without serving a Section 80 notice. If the government files a written statement defending the suit on merits without objecting to the absence of notice, the court may infer an implied waiver, as seen in Indian Singh Sabha Singh v. Union of India, AIR 1958 SC 274. Conversely, if the government raises the objection at the first hearing, the suit is liable to be dismissed unless leave is granted under Section 80, 2. Relevance of the Limitation Act, 1963. The Limitation Act, 1963, is intricately linked to suits by or against the government, particularly in prescribing time limits for filing suits, appeals, and executing decrees. Key provisions include: Article 112, A suit by the government for recovery of money or property has a limitation period of 30 years, as opposed to the general 3-year period under Article 6 for private individuals. For example, in NAB Rathanmal v State of Rajasthan, Air 1961 SC 1704, the Supreme Court upheld the government's right to recover arrears of rent within 30 years under Article 112. Article 136, the execution of a decree, including against the government, must be applied for within 12 years from the date the decree becomes enforceable. In Union of India v West Coast Paper Mills Limited, Air 2004 SC 1596, the court emphasized that delays in execution beyond this period require condonation under Section 5 of the Limitation Act. Section 80, CPC and limitation, the 2-month notice period under Section 80 does not extend a limitation period for filing a suit. In BL Gupta v MC Gupta, Air 1979 SC 1656, the court held that the plaintiff must account for the notice period within the limitation period prescribed by the Limitation Act. For instance, if a plaintiff has a 3-year limitation period to file a suit for compensation against the government, Article 72, Limitation Act, they must serve the Section 80 notice well in advance to file the suit within 3 years from the accrual of the cause of action. Leading case law. The following cases provide authoritative guidance on suits by or against the government and the notice requirement under Section 80, Bagchand Degajasa v Secretary of State, Air 1927 PC 176, this landmark Privy Council decision established that the notice under Section 80 is mandatory but can be waived by the government. The plaintiff filed a suit against the government without serving a notice, and the government did not object to the defect. The court held that the government's participation in the suit constituted a waiver, allowing the suit to proceed. This case is significant for its recognition of the government's discretion to forego procedural protections. 84 State of Punjab v Geeta Iron Brass Works Limited, Air 1978 SC 1608, in this case, the Supreme Court reiterated the mandatory nature of Section 80, dismissing a suit for non-compliance with the notice requirement. The court emphasized that the provision serves a public purpose by enabling the government to settle claims without litigation. The case underscores the importance of adhering to Section 80, unless waived by the government or dispensed with under Section 80. 2. Thien Singh Sabha Singh v Union of India, Air 1958 SC 274, this case clarified the concept of implied waiver. The government defended a suit on merits without objecting to the absence of a Section 80 notice. The Supreme Court held that the government's conduct amounted to a waiver, allowing the suit to continue. The case is a valuable precedent for understanding how courts interpret the government's actions in litigation. Practical illustrations. To illustrate the application of these principles, consider the following scenarios. 1. Suit against government for breach of contract. A contractor files a suit against the state government for non-payment of dues under a construction contract. The contractor serves a notice under Section 80 to the Chief Secretary, waits 2 months, and files the suit naming the state as the defendant. The suit is filed within 3 years of the breach, Article 55, Limitation Act. The government pleader represents the state, and the suit proceeds under Order 27. If the court passes a decree, execution is deferred for 3 months under Section 82, CPC. 2. Urgent suit without notice. A plaintiff seeks an urgent injunction to prevent a government agency from acquiring their land without due process. The plaintiff applies for leave under Section 80, 2, citing irreparable harm. The court grants leave, and the suit proceeds without a notice, as in State of Kerala v General Manager, Southern Railway, Air 1976 SC 2538. 3. Suit by government for recovery of property. The Union of India files a suit to recover encroached government land from a private individual. The suit is filed within 30 years of the encroachment, Article 112, Limitation Act, and the government pleader represents the plaintiff. No notice under Section 80 is required, and the suit proceeds as per the standard procedure under the CPC. 85 Question 19, explain the need and objectives of Limitation Act. Also discuss salient features of Limitation Act. Explain the need and objectives of Limitation Act. Also discuss salient features of Limitation Act. Need for the Limitation Act. 1963. The Limitation Act addresses fundamental concerns in the administration of justice, ensuring efficiency, fairness, and finality in legal proceedings. The need for such a statute arises from the following considerations. 1. Promoting timely justice. The primary purpose of the Limitation Act is to encourage litigants to pursue their claims promptly. Delay in initiating legal proceedings can lead to loss of evidence, fading memories, and difficulty in ascertaining facts, undermining the quality of justice. By prescribing time limits, the Act ensures that disputes are resolved while evidence is fresh and reliable. Illustration: a plaintiff seeks to recover a debt due on January 1, 2022. Under Article 55 of the Limitation Act, the suit must be filed within 3 years, by January 1, 2025. If the plaintiff delays beyond this period, the suit may be dismissed, ensuring that the defendant is not prejudiced by stale evidence. 2. Preventing perpetual legal threats. Without a limitation period, defendants could face indefinite threats of litigation, disrupting their lives and financial planning. The Act protects defendants by extinguishing the remedy, though not the right, after the prescribed period, promoting legal certainty and stability. Illustration: a property dispute arises in 2010, but the plaintiff files a suit in 2025, beyond the 12-year limitation period for recovery of immovable property, Article 65. The suit is barred, protecting the defendant from an unexpected claim after a long lapse of time. 3. Encouraging diligence. The Limitation Act incentivizes diligence among litigants, discouraging negligence or procrastination. It reflects the legal maxim vigilantibus non dormientibus juris obveniunt. The law aids the vigilant, not those who sleep on their rights. Illustration: a plaintiff, aware of a breach of contract in 2020, fails to sue until 2024, missing the 3-year limitation period, Article 55. The court dismisses the suit, reinforcing the need for timely action. 4. Reducing judicial burden. By barring stale claims, the Limitation Act reduces the burden on courts, allowing them to focus on current disputes. This enhances judicial efficiency and ensures that court resources are utilized effectively. 86.5. Harmonizing with procedural laws. The Limitation Act complements the CPC by providing a temporal framework for procedural actions, such as filing suits, Section 9, CPC, appeals, Section 96, CPC, or execution applications, Order 21, CPC. This interplay ensures that procedural mechanisms operate within defined time limits. Objectives of the Limitation Act. 1963. The objectives of the Limitation Act are derived from its need and are articulated in its preamble and judicial interpretations. The key objectives include: 1. Ensuring finality in litigation. The Act aims to bring closure to disputes by setting deadlines, preventing endless litigation that could destabilize legal relationships. 2. Protecting defendants' rights. By barring remedies after a specified period, the Act safeguards defendants from prolonged uncertainty. 3. Promoting equity. The Act balances the plaintiff's right to seek justice with the defendant's right to repose, incorporating equitable provisions like exclusions of time, Sections 12-15, and condonation of delay, Section 5. 4. Standardizing limitation periods. The Act provides a uniform framework for limitation periods across various civil proceedings, ensuring consistency in the application of law. 5. Facilitating access to justice. By allowing exclusions and extensions in specific circumstances, the Act ensures that genuine claims are not barred due to unavoidable delays. Illustration: a plaintiff, restrained by an injunction from filing a suit from January 1, 2023, to January 1, 2024, benefits from Section 15, 2, of the Limitation Act, which excludes the injunction period, extending the limitation period and facilitating access to justice. Salient features of the Limitation Act, 1963. The Limitation Act, 1963, is a comprehensive statute with several distinctive features that govern its application and ensure its effectiveness. These features are outlined below. 1. Comprehensive schedule of limitation periods. The Act contains a schedule with 137 articles, prescribing specific limitation periods for various suits, appeals, and applications. These periods vary based on the nature of the claim. Article 58, 3 years for a suit for a declaration. Article 55, 3 years for a suit for compensation for breach of contract. Article 65, 12 years for a suit for possession of immovable property based on Title 87. Article 136, 12 years for execution of a decree. Illustration: a plaintiff seeks to recover immovable property in 2025, based on a title acquired in 2010. Under Article 65, the suit is within the 12-year limitation period and is maintainable. 2. Commencement of limitation period. The limitation period begins when the right to sue accrues, as specified in the schedule. For example, in a breach of contract, the period starts from the date of breach. Article 55. Section 12, 1, excludes the day the cause of action arises from computation. Illustration: a contract is breached on March 1, 2025. The limitation period for a suit, 3 years under Article 55, begins on March 2, 2025, and expires on March 1, 2028. 3. Exclusions of time. Sections 12 to 15 provide for the exclusion of certain periods when computing the limitation period, ensuring fairness. Section 12 excludes time taken to obtain a certified copy of a decree or judgment for appeals. Section 13 excludes time spent on applications to sue as an indigent person. Section 14 excludes time spent in good faith proceedings in a court without jurisdiction. Section 15 excludes time during injunctions, statutory notices, or defendant's absence from India. Illustration: a plaintiff files a suit in a court lacking jurisdiction on January 1, 2023, which is dismissed on March 1, 2024. Under Section 14, the 14 months are excluded if the plaintiff acted in good faith, extending the limitation period. For condonation of delay. Section 5 allows courts to condone delays in filing appeals or applications, but not suits, if the applicant shows sufficient cause. This provision introduces flexibility, preventing injustice due to unavoidable delays. Illustration: an appellant misses the 90-day period for filing an appeal, Article 116, due to illness. The court may condone the delay under Section 5 if medical evidence is provided. 5. Continuous running of time. Section 9 states that once the limitation period begins, it continues to run unless interrupted by a statutory exception, e.g., Sections 12-15. No acknowledgement or part payment can extend the period unless made in writing, Section 18. Illustration: a debtor acknowledges a debt in writing on January 1, 2025, before the limitation period expires. Under Section 18, a fresh 3-year period starts from that date. 88.6. Legal disability. Sections 6 and 7 provide relief for persons under legal disabilities, e.g., minors, insane persons, by extending the limitation period until the disability ceases. Illustration: a minor's property is encroached upon in 2020. The limitation period, Article 65, begins when the minor attains majority, e.g., 2023, giving them until 2035 to file a suit. 7. Bar of remedy, not right. The Limitation Act bars the remedy, i.e., the ability to sue, after the prescribed period, but the substantive right persists. This principle distinguishes limitation laws from substantive laws extinguishing rights. Illustration: a plaintiff fails to sue for a debt within 3 years, Article 55. The right to the debt remains, but the court will not enforce it due to the limitation bar. 8. Applicability to special laws. Section 29 provides that the Limitation Act applies to special or local laws unless expressly excluded. For example, it applies to suits under the CPC but may be modified by statutes like the Arbitration and Conciliation Act, 1996. Interplay with the Civil Procedure Code, 1908. The Limitation Act and CPC are closely intertwined, as the CPC governs the procedure for filing suits, appeals, and execution applications, while the Limitation Act sets their time limits. Key points of interplay include: Section 9, CPC, civil courts have jurisdiction over suits of a civil nature, but such suits must be filed within the limitation periods prescribed by the Limitation Act. Order 7, Rule 6, CPC, requires the plaintiff to explain any delay in filing a suit beyond the limitation period, aligning with Section 5 of the Limitation Act. Order 21, CPC, execution proceedings must comply with Article 136, 12 years for execution. Illustration: a plaintiff files a suit for specific performance beyond the 3-year limit, Article 54. Under Order 7, Rule 6, CPC, the plaintiff must plead grounds for condoning the delay, which the court may consider under Section 5 if applicable. Judicial interpretations and leading case laws. The judiciary has played a significant role in interpreting the Limitation Act, clarifying its objectives and features. 89 BB Luhar v. PP Goyal, 1995, in BB Luhar v. PP Goyal, Air 1995 SC 2021, the Supreme Court emphasized the objective of promoting timely justice. The plaintiff filed a suit for recovery of property after the 12-year limitation period, Article 65. The court held that the suit was barred, reinforcing that the Limitation Act prevents stale claims to ensure fairness and evidence reliability. Analysis: this case underscores the Act's role in promoting diligence and protecting defendants from outdated claims, aligning with its objective of finality. State of Punjab v. Shamlal Murari, 1976, in State of Punjab v. Shamlal Murari, Air 1976 SC 1177, the Supreme Court interpreted Section 15(3), which excludes the notice period required under Section 80, CPC for suits against the government. The court held that the 2-month notice period is excluded, ensuring that procedural requirements do not curtail the limitation period. Analysis: this case highlights the Act's equitable feature of excluding time for statutory prerequisites, facilitating access to justice. Collector, Land Acquisition v. Kataiji, 1987, in Collector, Land Acquisition v. Kataiji, Air 1987 SC 1353, the Supreme Court elucidated the scope of Section 5 for condonation of delay. The court held that courts should adopt a liberal approach to condonation, considering factors like the applicant's bona fides and the absence of prejudice to the other party, to advance substantial justice. Analysis: this case emphasizes the Act's flexibility in preventing injustice due to procedural delays, aligning with its objective of equity. Practical illustrations to illustrate the application of the Limitation Act: consider the following scenarios. One scenario under Article 55, a contract is breached on February 1, 2022. The plaintiff files a suit for damages on February 2, 2025, within the 3-year limit. The suit is maintainable, reflecting the Act's encouragement of timely action. 2 scenario under Section 14, a plaintiff files a suit in a court lacking jurisdiction on January 1, 2023, which is dismissed on March 1, 2024. The plaintiff refiles in the correct court on March 15, 2024. The 14 months are excluded under Section 14, making the suit timely. 3 scenario under Section 5, an appellant misses the 30-day period for filing an appeal, Article 117, due to a family emergency. The court condones the delay under Section 5, allowing the appeal to proceed. Critical analysis: the Limitation Act, 1963, effectively balances the need for timely justice with equitable considerations. Its comprehensive schedule ensures clarity in limitation periods, while provisions like 90 sections 5 and 1215 introduce flexibility to prevent injustice. However, challenges remain, such as the subjective nature of sufficient cause under Section 5, which can lead to inconsistent judicial outcomes. The Act's interplay with the CPC ensures procedural harmony but requires litigants to navigate complex timelines, particularly in execution proceedings. Judicial interpretations, as in KTIG, advocate a liberal approach, but courts must balance this with the Act's objective of finality to avoid abuse. 91 Question 20, explain the law relating to ownership by possession. Explain the law relating to ownership by possession. Revision under Section 115, CPC. Section 115 of the CPC empowers the High Court to exercise revisional jurisdiction over subordinate courts to ensure that justice is administered correctly. The provision allows the High Court to call for the record of any case decided by a court subordinate to it, where no appeal lies, and to intervene if the subordinate court appears to have exercised jurisdiction not vested in it by law, failed to exercise jurisdiction vested in it, acted in the exercise of its jurisdiction illegally or with material irregularity. When can a revision petition be filed? A revision petition can be filed under the following conditions. 1. No appeal lies. The decision of the subordinate court must not be appealable under the CPC. For instance, interlocutory orders, e.g., an order granting a temporary injunction under Order 39, Rule 1, are typically not appealable under Section 96 but may be subject to revision. 2. Jurisdictional error. The subordinate court must have committed a jurisdictional error, such as excess of jurisdiction, acting beyond its legal authority, e.g., a court lacking pecuniary jurisdiction deciding a high-value suit. Failure to exercise jurisdiction, refusing to adjudicate a matter within its competence, e.g., dismissing a suit for want of jurisdiction when it has such jurisdiction. Illegal or irregular exercise of jurisdiction, acting contrary to law or procedure, e.g., passing an order without giving the parties a fair hearing. 3. Subordinate court. The court whose decision is challenged must be subordinate to the High Court, typically including district courts, civil judges, and other lower courts. 4. Material irregularity. The error must be significant enough to affect the outcome of the case, such as ignoring mandatory provisions of the CPC or misinterpreting evidence in a way that vitiates the decision. For example, if a trial court grants an ex parte injunction without hearing the defendant, violating principles of natural justice, a revision petition may be filed under Section 115, alleging material irregularity in the exercise of jurisdiction. 92. Scope of revisional jurisdiction. The scope of revisional jurisdiction is limited and distinct from appellate jurisdiction. The High Court does not re-evaluate the evidence or substitute its own findings unless the subordinate court's decision is perverse or patently illegal. In Major SS Canna v. Brigg F. J. Dillon, Air 1964 SC 497, the Supreme Court clarified that revisional jurisdiction is confined to correcting jurisdictional errors and does not extend to correcting errors of fact or law unless they result in a miscarriage of justice. Procedure for filing a revision petition. The procedure for filing a revision petition includes filing the petition. The petitioner files a revision petition in the High Court, accompanied by a certified copy of the impugned order and relevant documents. Limitation period. Under Article 131 of the Limitation Act, 1963, a revision petition must be filed within 90 days from the date of the order. Delay may be condoned under Section 5 of the Limitation Act if sufficient cause is shown, as held in Union of India v. West Coast Paper Mills Limited, Air 2004 SC 1596. Hearing. The High Court examines the record to determine if a jurisdictional error exists. It may stay the proceedings in the subordinate court pending the revision. Order 41, Rule 5, CPC, applied mutatis mutandis. Orders by the High Court. The High Court may confirm, modify, or set aside the order, or make any other order deemed just, but it cannot convert a finding on jurisdiction into a decree on merits. For instance, in a property dispute, if a trial court wrongly dismisses a suit for lack of jurisdiction despite having authority under Section 6, CPC, the aggrieved party may file a revision petition within 90 days, seeking to set aside the dismissal order. Reference under Section 113, CPC Section 113, read with Order 46, Rule 1, CPC, allows a subordinate court to refer a question of law to the High Court for its opinion when it involves a substantial question of law or the validity of any act, ordinance, or regulation. The reference mechanism ensures that complex legal issues are resolved authoritatively, promoting uniformity in judicial decisions. When can a reference be made? A reference can be made under the following conditions: 1. Pending case. The reference must arise in a suit or proceeding pending before the subordinate court. 93.2. Substantial question of law. The court must doubt the correctness of a legal principle or the validity of a statute, regulation, or ordinance. 3. Necessity for decision. The question of law must be necessary to decide the case. 4. No appeal lies. The reference is typically made when the court's decision on the question is not appealable, or the court seeks guidance to avoid potential errors. For example, if a trial court is uncertain about the interpretation of a new tax law affecting the plaintiff's claim, it may refer the question to the High Court under Section 113 for an authoritative opinion. Procedure for reference. The procedure for making a reference includes: statement of case. The subordinate court prepares a statement of the case, outlining the legal question, and relevant facts, as per Order 46, Rule 1. Submission to High Court. The reference is submitted to the High Court, which may call for additional records if necessary. Opinion of the High Court. The High Court provides its opinion, which is binding on the referring court unless overruled by a higher court. Costs. The costs of the reference are governed by Order 46, Rule 3, and may be borne by the parties or as directed by the court. Unlike revision, a reference is initiated by the court itself, not the parties, and does not require a jurisdictional error. Distinction between revision and reference. While both revision and reference involve the High Court's supervisory role over subordinate courts, they differ significantly in their purpose, initiation, scope, and effect. The following table outlines the key distinctions. For example, in a suit for specific performance, if the trial court wrongly assumes jurisdiction over a contract void under the Indian Contract Act, 1872, the defendant may file a revision petition under Section 115. Conversely, if the court is uncertain about the validity of a new contractual regulation, it may refer the question to the High Court under Section 113. Leading case law. The following landmark cases provide authoritative guidance on revision and reference. 94 Criterion Table 3, Distinction between revision and reference. Revision, Section 115, Reference, Section 113, Purpose to correct jurisdictional errors or to seek the High Court's opinion. Material irregularities in the sub on a substantial question of law. Ordinate court's decision or statutory validity. Institution initiated by a party through a re-initiated by the subordinate court vision petition. Suo motu or on application by a party. Grounds: jurisdictional error, excess, failed out regarding a substantial error, or illegal exercise of jurisdiction. Question of law or validity of action. Statute. Scope: limited to reviewing the sub or limited to providing an opinion. Donate court's record for jurisdiction on a specific legal question, notional errors, not merits. Reviewing the entire case. Stage: filed after a decision or order is made during the pendency of the past by the subordinate court. Suit or proceeding before a final decision. Outcome: the High Court may confirm, the High Court provides a bind, modify, or set aside the order. Opinion, which the subordinate court applies. Appealability: no appeal lies against a review. The High Court's opinion is bind final order unless it amounts to but the final decision in the decree. Suit may be appealable. Limitation period: 90 days from the date of the OR. No specific limitation period, as it Article 131, Limitation Act, is initiated by the court. Major SS Cannaby Brig F.J. Dillon, Air 1964 SC 497, in this case, the Supreme Court clarified the scope of revisional jurisdiction under Section 115. The court held that the High Court cannot interfere with findings of fact or errors of law unless they result in a jurisdictional error or material irregularity. The case involved a dispute where the trial court's order was challenged for exceeding its jurisdiction. The Supreme Court emphasized that revisional jurisdiction is not a substitute for an appeal and is limited to ensuring the subordinate court's decision is within its legal bounds. This case is pivotal for understanding the restrictive nature of Section 115. Banarsai Das v. Tikudutta, Air 2005 SC 2806, this case addressed the maintainability of a revision petition. The Supreme Court held that a revision petition is not maintainable if an appeal lies against the order or if the error complained of does not pertain to jurisdiction. In this case, the petitioner challenged an interlocutory order, but the court dismissed the revision, as the order was appealable under Order 43, Rule 1. The case underscores the importance of distinguishing between appealable and revisable orders. Province of Bengal v. Board of Revenue, Air 1961 calories 166, this case dealt with the reference procedure under Section 113. The subordinate court referred a question regarding the interpretation of a revenue statute to the Calcutta High Court. The High 95 Court provided its opinion, which guided the subordinate court in deciding the case. The case illustrates the utility of references in resolving complex legal questions, ensuring consistency in judicial interpretation. Relevance of the Limitation Act, 1963. The Limitation Act, 1963, is directly relevant to revision petitions but not to references, as the latter are initiated by the court. Key provisions include, Article 131, a revision petition under Section 115, CPC, must be filed within 90 days from the date of the order. In State of UP v. Brahmdat Sharma, Air 1987 SC 943, the Supreme Court held that delay in filing a revision could be condoned under Section 5 of the Limitation Act if the petitioner demonstrates sufficient cause, such as procedural delays or bona fide mistakes. Article 116, if a revisional order results in a decree, e.g., setting aside a dismissal order and remanding the suit, an appeal against the decree must be filed within 90 days to the High Court or 30 days to a lower appellate court, as per Article 116. For example, if a trial court's order dismissing a suit for lack of evidence is challenged in revision, the petitioner must file within 90 days. If the High Court sets aside the order and remands the case, any appeal against the remanded decree must comply with Article 116. Practical illustrations. The following scenarios illustrate the application of revision and reference. 1. Revision petition for jurisdictional error. In a suit for recovery of rent, the trial court dismisses the suit, wrongly holding that it lacks pecuniary jurisdiction. The plaintiff files a revision petition under Section 115 within 90 days, Article 131, Limitation Act, alleging excess of jurisdiction. The High Court sets aside the dismissal, finding that the court had jurisdiction under Section 6, CPC. 2. Reference for statutory interpretation. In a suit involving a new environmental regulation, the trial court is unsure whether the regulation applies retroactively. It refers the question to the High Court under Section 113, which provides an opinion clarifying the regulation's scope. The trial court then applies the opinion to decide the suit. 3. Revision versus appeal confusion. A trial court grants a temporary injunction under Order 39, Rule 1. The defendant files a revision petition, but the High Court dismisses it, noting that the order is appealable under Order 43, Rule 1, R, as seen in Banarsai Das v. Tikudutta, Air 2005 SC 2806. 96.